The Lordship heard this matter, hearing concluded, permitted me to file written submission.
Yes.
May kindly taken on record.
Take it. My lord, 12.
Item 90, my lord. Only 363 is there.
What do you want?
My lord, I want that, my lord, both parties are married. They are staying as husband and
What do
wife.
you want?
My lord, Lordship may fix a date for their personal appearance.
Huh.
So it can be quashed.
Fix a date. Fix
My
a
lord,
date. Next
after
week.
vacation, so both
okay.
are serving at outside.
Okay, after vacation, fixed date.
Go to date. 24 October. Okay,
Start.
interim order is there. Interim order to continue.
Item number 7.
Yes.
Item number 7. The charge sheet is not ready, my lord. So it will ready next week. So let it come next week, 1 week after, my lord.
Item 74. The AD not come, Lord.
74?
Yes, Lord. AD not come.
Dekho. Not received. Delivered. Yes.
Pardon to mention, my lord. CLMC 1629/2006 is a Baleswar sex scandal case, my lord. Prashant Kumar Naik versus Republic of India.
What do you want?
I filed a fresh IA for the call for records from the lower court.
Let it come. What is the urgency?
But, it hasn't filed in the month of June till that.
It will come. Serially it will come. Yes.
I didn't 106. Today, my senior is not available today.
106. Adjourned. Yes. Sir.
Item 1.
Oh. This matter I reserved the judgment, but I am recusing for some reason because it one point in time in Supreme Court I appeared for the state. I discovered that while dictating the judgment, I saw that I appeared for the state. This case.
Sir, we also thought that.
Sorry, sir.
We also thought that.
So
because the judgment was reserved on 1st August.
My 5 hours of hearing and 2 hours of study has gone waste. Anyway, that's part of it. Yes.
Item 2.
May I please your lordship, my lord, kindly have a glance to the order passed on 22/8.
Order?
Passed on 22/8.
22/8.
Yes, my lord.
Yes.
On that day, the victim girl was present.
Yes. Where are the accused?
Accused is here, my lord.
Huh?
Accused is here, my lord.
Yes. Then
I have also taken instruction, my lord, from the IO.
yes.
That victim married somewhere else, my lord. She is residing happily with her husband.
To save her marriage there.
She did not want to proceed.
Right. At the instance of opposite party number 2, the FIR number so came to be registered against them. The see in the the matter was taken up for hearing on 22/8/2024. The following order was passed. Mr. Ragada, led counsel for the state, submits that the concerned police
IAC Begunia PS.
IAC Begunia
PS. Begunia PS.
Begunia PS has also verified the fact.
The father of the victim stated that contacted is ascertained that the victim such and such has already married to one Santosh Kumar Devata of village.
Verified the fact that the victim girl has already married to one Santosh Kumar Devata
In the year 2023.
in the year 2023.
At present, she is not interested to proceed further into the.
Interested to proceed with the present proceed with the prosecution against the petitioner.
And she has also filed affidavit before the police.
She has also filed an affidavit before this court, which is affidavit before this court.
One thing mentioned, my lord, since SC Act is there, my lord, investigations are carried by the DSP, investigation pending. That
why should I write that? She has also filed an affidavit dated 22/8/2024, reiterating the aforementioned fact, so as to save her marriage she doesn't want to proceed with this case. She apprehends that if this case would be going on, her marital life may be jeopardized. Hence, he joins with the petitioner for seeking quashing of both regarding that to the aforementioned and the judgment of the Honorable Supreme Court in Jansing and so on, so on, so subjecting the petitioner to rigors of the trial would be a futile exercise. Therefore, the petition deserves merit. Accordingly, it is quashed. Yes.
Item 3.
Item 3, your lordship, permitted to withdraw with permission to refile if with better particular.
Right, Mr. Sadangi and senior counsel appearing for the petitioner seeks to withdraw this petition with the liberty to file a fresh
with better
particulars and documents. Yes.
Item 4.
Yes. Yes, sir.
Passing under ground of compromise.
Compromise. Where are they? What is the offense?
Page of 7 is there, my lord.
What are the
Gunshot injury and grievous.
That's right, but gunshot injury and arm check.
Yes.
Yes, my lord, but I have given on the last occasion, I have.
You show me some judgment, the gunshot
Yes, my
injury.
lord.
We have already given a
Judgment, sir, kindly say the judgments in the.
Yes. Earlier given, my lord, one
Nirantar
judgment.
Singh versus.
Knife used, knife.
Knife, gunshot, you show me. No, guns are,
Intervention of the Sarpanch and other.
whatever, whoever may be, then Sarpanch will decide the case.
No, my lord, in that judgment.
You,
in that-
I'm not dismissing your petition. I'm just help me out.
Ah.
Give me some judgment of any high court, anything where gunshot injury is there, 307, I can do it.
Former Chief Justice of India Thila Ramana Tankar.
Get some judgment so that I can.
Justice
Mr. Das can help you out.
Justice
I'm
Ramana's
putting-
judgment is there.
I'm putting it next week. You speak to Mr. Das. He has a vast knowledge in this.
Justice Ramana, 3 judges bench of the apex court, your lordship knows better. That is there.
Get the judgment. I'll cite it and do it.
Criteria is that whether they have any antecedent or not. And 307, that has been also passed. 3 judges.
But gunshot.
That is, he has to verify.
That's what I'm saying. Gunshot because arms act is involved.
ସେଥିରେ criteria କରିଦେଇଛନ୍ତି. Criteria ଅଛି 7ଟା ନା 10ଟା criteria.
You get that judgment. If some help
That
is
judgment he is
taken.
citing. What my friend saying, my lord, that judgment he is
ଆଉ
citing.
ଅଛି ସୁପ୍ରିମ କୋର୍ଟ ତାପରେ
Now, that judgment-
Find out some gunshot thing. Next week.
ଅଛି
Next week.
Gunshot item.
Next week.
ନା ନା ଏଇଟା
Get some
ନୁହଁ
judgment.
ନା ଏଇଟା ନୁହଁ
I can write a judgment which is tenable under law. Get some.
for benefit of the party.
Obviously, then other matters also it can be.
ଏଇ judgment ଟା ନୁହଁ ଆଉ ଯୋଉ 3 judges
Ah.
my lord justice CJI
Please put some level and get assistance from me. Next week.
Present में
They are accused. They are not VIP. They are not. Don't ask these things on behalf of your client. What is the big deal coming? You are coming every day. Why can't they come? After all, they have
recording
attempted to kill someone.
my lord only.
Why are you making this kind of prayers? Are they VIPs?
My lord, all right.
Every day they'll come.
My lord.
You are asking. Yes.
Item 5.
Get some judgment, gunshot. You will get from say any high court or somewhere. Find it out. Yes.
Item 5.
Yes, ma'am.
Fine.
Item 5,
Yes.
of challenging the order passed by the SDGM Jagshampur in GR case number so and so
Yes.
under section 25 of CRPC. I have filed a application under
05.
245, my lord. 245 CRPC.
Discharge.
Discharge. But learned SDGM said that you should have filed 239.
You file.
In that ground only they have rejected my
Okay, you file it. Who stops you? Why have you come to this court?
because the
Where is that part? Where is that?
in page number 13, my lord.
1313.
13 para number 2 last part. Therefore, this court is of considered opinion that learned counsel of accused should have filed a petition on the
Where are you reading, sir?
second
13?
paragraph last part.
Okay. Therefore, this court is of the considered opinion that the Learned Counsel for the petitioner should have filed a petition under 239 CRPC instead of filing the present petition by invoking 245 CRPC for discharging of the accused and commission of alleged offense, and which is not at all tenable under the eyes of law. You file it, who stops you?
That liberty may be
Right now,
given.
Learned Counsel for the petitioner submits that his application under section 245 CRPC for discharge has primarily been rejected by the court below on the ground that he ought to have filed a petition under section 239 CRPC instead of 245 CRPC. He seeks to withdraw this petition to file a fresh application before the trial court under section 239 CRPC. The petition is dismissed as withdrawn with liberty as read. Yes, next.
Obliged.
In this case, the petitioner has filed an application under section 482 for quashing of the entire proceeding, criminal proceeding instituted against the petitioners under the Prevention of Food Adulteration Act, my lord.
Prevention of
Food Adulteration
Food
Act.
Adulteration Act. Yes, so the ground.
My lord, ground is, if your lordship sees, there are basically two grounds, my lord. One is that the prosecution was initiated in the year 2000, my lord. And till now, only 3 witnesses have been examined. And this is the second journey of the petitioner to this honorable court, my lord. Earlier, the honorable High Court, this honorable court directed the SDGM to conclude the trial within 4 months, and the government council also undertook that they will cooperate with the case, my lord. Now, if your lordship sees the
Why it was it could not be.
my lord, the food inspector was not available. He was not coming to the court.
Has the trial court sought extension of time?
No, my lord.
Where is that order? Show me.
Yes, my lord.
Where is that order of?
My lord, order of
court?
this honorable court is at page 20, my lord.
20.
Yes,
This one? 2010.
2010.
Where is that? Therefore, it dispose of this, application directing the learned SDGM Keonjhar, Keonjhar to conclude the trial. What is then I'll ask for a report from the trial court. I'll ask for a report. What is why?
That apart, my lord.
For the petitioner submits that on 9/12/2010, this court, while allowing CRLMC 2534 of 2010, directed the SDGM Keonjhar
Yes.
to conclude the hearing of the complaint case, subject complaint case, within a period of 4 months. Despite this order, the matter is prolonging since more than a decade.
23 years. my lord.
23 years.
Now
More than
23
23 years. Call for a report from the SDGM Keonjhar. Leave the matter after 1 week.
My lord, this
If that
apart,
is the case, I'll pass it. Yes.
this apart, my lord, one more ground I have.
Oh, this, let it
Okay.
come. Let it come. If this grounds suffice
My
to
lord,
23 years, why should you suffer?
my lord, my lord.
I'll pass on that now. Yes. Withdraw?
Say permit to withdraw.
Withdraw, yes. Thank you. Yes.
Case admission and appellant is in custody because of conviction of 4 years since 28/8/2024.
Undergone?
Under section 7 of the PCR.
How, undergone how much?
Undergone 28/8 ରୁ ଆଜି ପର୍ଯ୍ୟନ୍ତ ଯେତିକି ଦିନ ହେଲା
28
28/8 ମାନେ 13 ଏଇ ଆଜି 13 ସେ 4 17 ଦିନ ଆଉ।
ठीक है.
Under section 7.
Appeal admitted, bail granted, subject to the satisfaction of the trial court, realization of fine date, call for the record.
Another petition for stay of the sentence also.
I object. I object.
Sentence?
Stay of
Stay
sentence.
the sentence, yes.
Stay of sentence.
Let LCR be called up.
I have called for LCR. Normal.
Okay, at that time, after receipt of the LCR, that will be taken.
Bail granted.
Yes.
Realization of the fine state, that's all, not beyond that.
Reflected.
Should be there.
All right.
Yes.
cause list and
Cause list as well as
May
yes, sir.
may please, your lordship.
Yes, sir.
Last occasion,
I
your
think
lordship
what
was.
happened, my lord?
The case that is available in its BLAPL note 2508/2024, my lord. That has been listed before this only court, my lord. That has been adjourned, my lord, to some other date.
Which date?
Co-application application, my lord.
Least the
2508
please the present application along with
BLAPL number 2508/2024.
2508 लिख दो and जब लगेगी सही दिन पे लगेगी ठीक है next
Please, your lordship, my lord. Your lordship, may kindly go through the last order where your lordship was pleased to call for a status report from the learned court below.
status report has come. Yes.
The case.
Yes.
I'm in custody since 7/9/2023.
The victim no. PW1 Singh.
No, victim is one
What is the name of the victim?
Tapaswini 4.
Yes, that evidence has come. Usually, the alleged incident is about 1 year ago. They took See, this is, I'll tell you, this statement of the victim as well as the mother of the victim has been recorded on 28/2/2024.
My lords.
8/2024. And she has supported the prosecution and said everything against her.
Your lordship, may kindly have a glance to
No,
that.
I'm not, I have read it, the entire. Have you read this evidence?
Yes, my lord. Therefore, I wanted
No,
to.
this is recorded subsequent to your rejection of the bail, you go to the trial court, right on. Petitioner is agreed by the order dated 1/2/2024, whereby his bail plea has been rejected. Subsequent thereto, the victim girl has been examined as PW2
Two, my lord.
on 28/2/2024. And the mother of the victim has also been examined as PW1 on the same day, And in the changing circumstances, petitioner should approach the court for the first instance by renewing his bail plea. With this observation, the petitioner is disposed of. Yes, next.
Grateful, my lords.
May
My lords, may I pray, your lordship may also indicate that this order may not be influenced by the learned
Right,
court.
it is needless to say that the bail application to be moved by the petitioner shall be dealt with on its own merit without being influenced by the observation already made by the trial. Yes.
24/8/2023.
Huh?
24/8/2023. Deceased committed suicide, blocked the door inside the room.
Yeah,
And to that effect, I am placing.
Record came.
My lord.
Yes. You are the husband.
Yes, my lord.
Yes.
I'm
Custody.
24/8/2023.
24/8/2023. Okay.
Deceased committed suicide, blocked the door inside the
Show
room.
me that part.
Yes, my lord. I am placing one statement. Manoj Sethi, petitioner, Chennai re rahi gotiye hotel re kaam kare, 7,000-8,000 टका
Whose
दरमा
evidence is that?
independent witness.
What name?
Name my lord, नाम मालती सेठी my lord.
Malati.
Yes, my lord. Many witnesses same my lord. ବିବାହ ପରେ ମନୋଜ ସେଠୀ ତା ସାଙ୍ଗରେ ସେଠାରେ ରହିବାକୁ ଇଚ୍ଛା କରୁଥିଲା, କିନ୍ତୁ ମନୋଜ ସେଠୀ କମ ଦରମା ପାଉଥିବାରୁ ତାକୁ ସେଠି ନେଇ
Come to the point. Why are you reading the history?
Yes, my lord. Come to ଅନ୍ 21/8/2023 ଉପେନ୍ଦ୍ର ସେଠୀଙ୍କର ସାନ ଭୀମସେନ ସେଠୀ କ୍ୟାନ୍ସରରେ ମରିଯିବାରୁ ତାଙ୍କ ଶବ ଡାକ୍ତରଖାନାକୁ ଆଣିଲେ। ଆମେ ସମସ୍ତେ ଭୀମସେନ ସେଠୀ ଘର ପାଖରେ ଥିବା ସମୟରେ ଏହାର ସୁଯୋଗ ନେଇ ବେବିନା ଡିସିଡ୍ ତାର ଶୋଇବା ଘର ପଙ୍ଖାରେ ନିଜ ଲୁଗାରେ ରସି ଲଗାଇ ଆତ୍ମହତ୍ୟା କରିଛି। ବେବିନାର ଶାଶୁ ଜେନାମଣି ସେଠୀ ଭୀମସେନ ସେଠୀଙ୍କ ଘରୁ ଆସି ନିଜ ଘରକୁ ଆସି ବେବିନାକୁ ଡାକିଲେ, ସେ କିନ୍ତୁ କଣ ଉତ୍ତର ନ ଦେବାରୁ ତା ଶାଶୁ ଶୋଇବା ଘରକୁ ଯାଇ ଦେଖିଲେ ବେବିନା ଭିତର ପଟୁ କବାଟ ବନ୍ଦ
Yes.
କରି ପଙ୍ଖାରେ ଝୁଲୁ।
Anything?
That is true, my lord. But in fact, my lord, within 2 months, my lord, of marriage.
But he is in custody since 1 year, right? Petitioner is accused of the source of political allegation against the petitioner. He first probably I have perused the statement of witnesses recorded under section 161 CRPC. All the witnesses have stated that although the petitioner was married with the deceased for about 2 months, and he has been torturing, allegedly torturing her. But on the fateful day, the victim has committed suicide by bolting the door from inside. The petitioner is in custody since 24/8/2023. Regarding to the nature of accusation and period of custody, I am inclined to allow. Yes, next.
Item 13. Ma'am.
Yes.
Offense lordship, 302 lordship.
13, huh? Yes, sir.
302 lordship and
Speak little louder. Yes, 302.
302 lordship.
CD has come?
CD.
Yes, 302.
Last
Yes, sir.
occasion lordship directed to obtain instruction regarding status of the case lordship
Right.
and the status of the trial lordship, and it is not commenced lordship. It's
Not
waiting
commenced.
for charge.
And see, you are in custody since?
Custody since lordship 23/8/2023 lordship.
23/8/23. Okay.
Lordship,
Yes. What are the allegations?
Lordship prior to
Yes, Mr.
come to
Nagada,
the-
is there anything?
My lord, I have
Lord.
read out this
Sumanta Pradhan.
statement, my lord. One Gita Naik, my lord. रिलेवेंट पर्सन माय लॉर्ड कि समय तार भाई दूसरा प्रधान गोटे टांगिया सुमत प्रधान पिटिशन माय लॉर्ड गोटे लाठी धरी आसी घर पाखरे पहुंचले मो भौन को कहीं पिटिल बोली कही पाटितुंड कर दूसरा प्रधान धरती टांगिया रे मोर बाम पाख मुंड को हाणी रक्तात कला सुमत प्रधान धरती ठेंगारे मोर बाम हाथ में माड़ मारी रक्तात करने सह देह सारा पिटी मरा करी फुलाई देला. Other eyewitnesses also stated same, my lord. There are eyewitnesses, my lord.
How many eyewitnesses?
My lord, there are, my lord, more than 3 to 4 eyewitnesses, my lord. Sarat also same, my lord. Sarat Chandra Pradhan, my lord.
May I pray?
He has stated,
eyewitness to be examined.
Lordship, may I pray, Lordship? Only one thing, Lordship. Cause of death, Lordship, safety semi. After 20 days, Lordship. After 20
beaten
and
so
this-
much, 15
Lordship,
days septicemia may will happen.
While under
Take
20
khali.
days expired.
Arising out of injury, Lordship, no doubt. Arising out of that injury, Lordship. But family dispute, Lordship, and there was a compromise, Lordship. There was a compromise, Lordship.
The direct allegation is you have brutally assaulted.
My lord.
Lordship,
And
Amma have
the
to
result of which he
Lordship,
suffered with septicemia
Seটা again
and died.
12 years girl again statement টিকে ମୁଁ ଖାଲି ପଢି ଦେଇ ସେ ବାମ ହାତରେ assault କରିଛି ବୋଲି କହିଛି ଆଜ୍ଞା ବାମ ହାତରେ assault କରିଛି କହିଛି ଆଉ ଆଜ୍ଞା ସେ date of occurrence lordship 5/8/2023 lordship and immediately day after shifted to medical and after treatment lordship very next day he discharged lordship very next day discharged. Injury was simple lordship. Injury was simple.
Septicemia thereafter.
Thereafter lordship after 20 years septicemia is because of lordship. This is a family matter, Lordship. There is
Maybe
no
family
other
matter doesn't mean.
Lordship. Only because Lordship.
302, it's a 302 case.
Lordship.
Right?
So far as assault part is Lordship.
I'm giving you liberty within 6 months, all the witnesses to be examined.
Till that charge is not framed, Lordship.
Charge has not been framed.
Lordship.
Okay, no problem. The petition is agreed by the order dated 5/2/2024, whereby his bail plea has been rejected. Although charge sheet has been filed, but the charge has not yet been framed. In the course of the petitioner submits that although charge sheet has been filed, but charge has not yet been framed. There are, the Mr. Raghunath, learned counsel for the state, has pointed out that there are 4 eyewitnesses who directly implicated the petitioner. And therefore, I am not inclined to enlarge the petitioner on bail at this stage. However, petitioner is given liberty to renew the bail plea after the examination of the eyewitnesses, and the trial court is directed to do well to see that all the eyewitnesses are examined preferentially over the other witnesses, and the petitioner is also given liberty to renew the bail plea after 6 months
May I
if for any reason the witnesses, eyewitnesses cannot be examined.
May I
Cannot be
tell
kept
Lordship?
with this liberty, the petitioner is disposed of. Yes.
After charge, may I renew my prayer, Lordship?
Eyewitnesses.
Charge may be, it is at best, Lordship, 307
Let
ଆସିବ.
us
Charge ପରେ ଆସିବ, 307 ଆସିବ, Lordship.
see, after charge, if you come, I will not record all these things, and better that your evidence will be concluded. Which, see, within charge, you move the application after 2 months, again it will be 4-5 months for hearing. Better that within 6 months your evidences are recorded. It is good for you. Think in that perspective. Within 6 months, at least eyewitnesses can be recorded.
Examine କେତେବେଳେ ହବ କିଛି କହିହବନି.
Huh?
କେତେବେଳେ ହବ?
I am giving you 6 months. In any case, you have to renew. This is to your benefit. Therefore, I am saying, if you want, I can very well tell you, give you liberty. Renew your bail plea after the charge is framed, and it will be rejected.
I said there are eyewitnesses.
Eyewitness.
4 and more than 4 or something. Eyewitnesses.
Eyewitnesses.
There are eyewitnesses.
Yes. Yes. Next. 14.
May I please your lordship? I am in VC, your lordship. May I please your lordship? Am I audible, your lordship?
Yes, yes.
The petition is in custody since 31/1/2024, your lordship.
31?
31/1/2024, my lord.
Yes.
My lord, the victim is a major lady and married lady, my lord, who is the informant, and the petitioner is also a married person. And in the meanwhile, charge sheet has been submitted under section 376(2) and 387, 419.
You are appealing for?
Informant.
Informant. What do you say?
My lord, the petitioner giving intoxicating the victim committed rape, recorded that video, and showing that blackmail. All total, my lord, 7,87,000
Taken money also.
Taken money from account, from the phone pay of the informant. Taken money and taken all the gold ornament.
You have a.
My lord, occurrence took place in the year 2022, your lordship.
All the gold ornament, mortgage that money from finance. Police also sees that the video, the photo.
You have done 3 things. One is the rape. Second is viraling the photographs. Third is you have taken money.
Not viraling or threatening to viral, not viral, your lordship. Threatening to viral.
The victim has been examined.
164 recorded, but trial not commenced.
Let the victim be examined. Right now.
My lord,
By the order date.
the lordship may kindly make some cash surety, your lordship, because my lord, the only one person is there.
During investigation, the statement of the victim girl has been recorded. She has made specific specific allegations against the petitioner regarding the forceful sexual intercourse, sexual assault by administrating intoxication, by intoxicating her, and she has also stated that the petitioner has been blackmailing her by showing the
Nude videos,
nude photographs. In that process, the petitioner has also taken
7,87,000
7,87,000
and gold ornaments,
along with gold ornaments from her.
which is
Regard being had to the nature of acquisition, I am not inclined to enlarge the petition on bail. However, since the petitioner is in custody since 31/1/2024, liberty is granted to the petitioner to renew the bail plea after the victim is examined, the trial court is directed to see that the victim is examined preferentially over all other witnesses. Disposal. Next. Item 50.
Obliged, your lordship.
Passos. Today, why are you asking? Withdrawal. There is a memo for withdrawal.
I have the one IA have been filed, lordship. For the reason the extension time of surrender, lordship. Earlier, the honorable court granted interim protection, interim bail.
Where is the question of extension of time?
Lordship,
You have to surrender, that's all.
I have also
Extension-
surrender. Surrender certificate has also been filed, lordship. Then the tag. Tag is the.
What do you want? You are asking for withdrawal also.
No, lordship.
Yes, my lord, he has filed a memo.
File a
Memo has been
IA,
filed for
lordship.
withdrawal.
IA, lordship. Kindly see the IA, lordship.
IA for the extension of time.
Yes, lordship.
Okay, you have surrendered therefore.
Let
Counsel for the.
I will
petitioner,
also file the
seek
surrender
to withdraw
certificate,
the
lordship.
IA number
1065.
1065, whereby he has sought for extension of time for surrendering. He submits that since the petitioner has already surrendered, this application has become infructuous. Therefore, he seeks to withdraw the same. Dismiss as withdrawn. Yes, main matter. You tell me.
Pass over, lordship. No, pass over.
No matter today.
Lordship,
My lord, when he has surrendered, lordship, when he has surrendered, then the matter be taken up after vacation. My lord.
No,
Because
lordship.
just now he has surrendered.
No.
176.
No, I will.
In time, lordship. In time, I will
Victim is
always.
coming. Victim is
Yes,
has
lordship.
already
Victim coming.
is in the line for.
Yes, lordship.
Letter come. I
Pass
will-
counter, lordship.
Victim, there is no order that the victim will be present before the court. That is
I
no
will
such
He,
order.
he
But
went
I
in
filed-
went in the interim protection. He managed it now. That is
my
why he went out.
And he has last occasion, he also stated that 164
He
question.
went out only to manage the victim. Let her come. Let her come. Let
Yes,
her
lordship.
come.
No, whether she was deep, she was examined or not, because he has prayed that
Let her
to file
come.
the
We'll see
deposition.
how she to what extent he has managed.
Deposition ଦିଅନ୍ତୁ copy.
ଆସୁଛନ୍ତି
That
ନାଇଁ?
was-
ଏତେ ବ୍ୟସ୍ତ ହେଲେ ହବ? ବହୁତ ପ୍ରତି ଆସୁଛନ୍ତି।
Interim. That is the reason he took interim order. Why for it? He would
It was also extended.
successfully managed the victim. Yes. Next.
Item 16.
May I please, your lordship? Initially, the FIR was lodged under 394, 225 and 27
Yeah,
arms act.
custody.
And in the meantime, your lordship has granted
one
bail to the
co-accused has
co-accused
been-
persons having antecedents, but the petitioner has not single antecedent.
Well,
only
one
this case.
co-accused person has been released on bail. From
Right.
that, one anklet was seized, and there is also some antecedent. He has to clarify whether there is antecedent or not. Similar
There is
order
no
may be passed.
antecedent.
Your lordship may pass.
Subject to verification of.
My lord. And lordship may pass similar order.
Further is the co-accused persons have also already been enlarged on bail by this court by the order dated 12/8/2024, while in BLAPL number 2479 of 2024. Then counsel for the petitioner submits that although the co-accused persons had antecedent, they have been enlarged on bail. Insofar as the petition is concerned, he has no antecedent. Subject to verification of the antecedent granted. Yes.
With that,
Custody form?
Able.
Custody since?
Custody since 12/11/2023,
12
more than 10 months.
my lord, with same condition. In
With
which,
all conditions, same conditions. Item number.
Item 17.
Yes.
May I please, Your Lord?
Yes, madam.
FI laws for offences under section 376(2)(n) and 417.
Custody since
custody 6 to 24.
6 to
6
24.
to 24. Yes,
Your
madam.
As per-
164. Read 164.
My lord, 164. The petitioner, my lord, is a married lady having 18 years girl child.
He is also 45 years.
My lord, no, victim is 19 years.
19 years.
Present petitioner is 45 years. Having a daughter.
They were in love relationships.
What law relation? 45 having a 18-year-old girl, and you have a relationship with a 17 years old.
And that
No,
petitioner has an 18 years child. My lord, girl child is
I
18 years.
may be permitted to read.
Girl is younger than your daughter.
Yes, Your Lordship, rather she is compelling me. She is Your Lordship, trial has already been started and victim, let it be listed on.
No. I will not see the idea of POXO Act is defeated. If this kind of
POCSO.
I am only granting bail looking at the boy, the age of the boy. If the boy girls are very younger, same age group, this may happen. But you are you
POCSO is
have
not there.
exploited a girl who is younger than your daughter.
Lordship, here POCSO Act is not there. A girl is 22 years old. POCSO is not there.
19 years.
See,
19.
right.
19 or what? Less than 19.
19 years. And the petitioner daughter is 18 years.
Examine
Madam.
trial this Sakhi Galan, sir, let this.
You renew the bill. 17 na item 17. Right. Petitioner is agreed by the.
Deposition copy ta nehi asibi ase rahi tha. Lordship already examined hei galani bodhi.
1 minute, madam. Petitioner is agreed by the order dated 10/4/2024. Subsequent thereto, the evidence of the witnesses have already been examined by the court below. In view of the changing circumstances, petitioner is given liberty to renew the bail plea before the trial court, If such application is moved, same shall be considered on its own merits. I will not say anything on merits because it is prejudicial.
After examination, after
Right.
examination of the victim,
Yes.
that may be reflected in order.
After the renew the bail plea, after the examination of the victim. Yes.
In this case,
Yes, sir.
in this case, Lordship, Mr. Mishra is no more, Lordship, and I have power in this case, Lordship, but file is not available with me. Let it come next week,
The
Lordship.
petition submits that the earlier counsel, Mr. Mishra is no more. Mr. D.R. Mishra has expired, hence he seeks an adjournment. Release the matter after 1 week.
Next week, Lordship.
Next week. Yes.
May I appeal, Your Lordship? The petitioner is a 60 years old man, my lord, who has been implicated.
60.
60.
60.
60 years. Yes.
376.
No, my lord, 20B2C of the
20B2
NDPS Act. my
NDPS.
lord.
What is the recovery?
He is in 50 kg ganja has been recovered from the roadside.
I am granting, granting. 50 kilo.
50 kg and
Custody?
custody 16/3/2024.
16/3/2024.
16/3/2024.
2024. Yes.
Okay. 16/3/2024. Petitioner is a 60-year-old man. 60-year-old recovery to the granted with antecedent. Antecedent check. Okay. Yes.
And with some condition, madam.
Condition. All the condition and antecedent.
Right.
You are
antecedent
from Orissa or somewhere else?
Antecedent gote achi aage. Gote achi, but chaso houtela gote government jagare sethi.
Whatever. You are from Orissa or somewhere else?
No, Odisha.
Odisha.
You do your job. Subsequently, what will happen? That is paid.
Like gote antecedent achi bole kahi deli. Otherwise,
I am not recording that. I am only granting you the bail. At least let him have the satisfaction of bail. It will come out or not, that's a different story. Yes.
Item 20.
20.
21 call for a report from the court below.
Madam, the metro day before yesterday petition of court. Madam, see the report.
That withdrawal. Yes, yes. Let us see. Okay. What is the report? What is the report? Give me the report. Huh? Where is the report? Flag? B. 20 item?
20 item. Item
20.
Flag C.
Flag C. Where is flag C? Yeah? Where is flag? The report is the dealing assistant is a new entrant. What to do? So the report is escape with notice.
Young counsel,
Yes, Mr. Chand, what to do?
But definitely, because of the fact that suppression, the bail granted, it requires to be reconsidered by due to place before the my lord the justice.
The dealing assistant being a new entrant, why
No,
to?
I have no, because at times it happens. And one more, my lord, one thing, my
Might
lord,
have escaped notice because of
yes,
inexperience.
yes, at times, my lord, and one thing, my lord,
I'm not
practical
proposing
is-
to take any action against the officer of this
No,
court.
totally not, my lord. It is
But
also
in the
not my.
same time, I think this is a case where bail should be concerned. So I'm sending it to the concerned court. Okay. This matter was taken up on where is that order? Where is that order? Last one. Not uploaded. Not uploaded. Taken up on-
7193 of 2024, my lord. I was given a copy.
This
Must
court
be available with record.
following. Subsequent thereto, the registry has submitted a report. Which reads as in view of the aforementioned report of the registry, I feel it appropriate to place it before the concerned bench to pass appropriate order, pass appropriate order in the present matter, subject to leave the matter to the coordinate bench, subject to the approval of the honorable chief justice. Yes. I place it before the concerned court. Yes, thank you very much. Yes.
21, my lord, the present petitioner has already been acquitted.
Acquitted.
Postco case acquitted.
Yes. 22.
May I please, your lordship? My lord, charge sheet submitted under section 376(3).
Yes.
506 and
Notice was issued. Notice.
Informant was appeared.
Appeared.
My lord.
My lord,
Yes,
the
sir.
case is that, my lord, if informant who lodged the FIR with the mother of the victim,
Custody since?
my lord, I'm in custody since
2010, 23.
2023.
10/23. Eh?
My lord. My lord, it's a my lord, particular case, my lord, when the victim's mother lodged the FIR, stating therein as if
Read the 164.
Yes.
Relevant portion I am reading.
My lord, I'm
the
submitting thereafter, your lordship. Brief case.
You are not sure that you have a good case.
Yes, sir.
I will read
that. Will
that part. If I am satisfied, I'll grant. Don't tell anything. I may get prejudiced. Wait.
I am reading
If
the
I am not satisfied, then you tell me.
Okay, sir.
Yes.
relevant portion I am reading.
164 statement.
That mu ଆମ
ପୁରାଟା
ସ୍କୁଲ
ଦେଇଦିଅନ୍ତୁ।
ସାମ୍ନାରେ
ପଢିଦବା
ବସି
ପାଇଁ।
What
ସଂଗ୍ରାମ
age of this?
13 years.
13 years.
ସ୍କୁଲ ସାମ୍ନାରେ ବସି ସେ ଆମକୁ କମେଣ୍ଟ ମାରନ୍ତି। ମୁଁ ସାଇକେଲ ଦେଇ ସ୍କୁଲ ପଳାଇବା ସମୟରେ ମୋ ସାଙ୍ଗ ମତେ ଆସି କହିଲା ମୁଁ କାହିଁକି ମୋର ସାଇକେଲ ସଂଗ୍ରାମକୁ ଦେଲି କାରଣ ସେ ସବୁବେଳେ ମୋର ସେଇ ସାଇକେଲ ପମ୍ପଚର କରେ। ପ୍ରେଜେଣ୍ଟ ପିଟିସନ। ତାପରେ ମ୍ୟାଡମ ରିଲିଭାଣ୍ଟ ପାର୍ଟ ଗୋଟେ ଦିନ 7/23 ମୁଁ ଟ୍ୟୁସନ ଯାଇଥିଲି ମୋର ସାଙ୍ଗମାନେ ମୋ ସାଙ୍ଗରେ ଯାଇନଥିଲେ ସେଇ ସମୟରେ ପିଙ୍କି ନାୟକ ଟ୍ୟୁସନ ସରିଲା ପରେ ପାଖାପାଖି 2:30 ଖରାବେଳେ ସ୍କୁଲରେ ମୋତେ ଜବରଦସ୍ତି ତାଙ୍କ ଘରକୁ ଡାକିଲା ମୁଁ ମନା କରିବା ସତ୍ତ୍ୱେ ସେ ଡାକିଲା ତାପରେ ମୁଁ ବାଧ୍ୟ ହୋଇ ତାଙ୍କ ଘରକୁ ଗଲି ଏବଂ ସେଠାକୁ ଯାଇ ତାର ଝିଅ ସାଙ୍ଗରେ ଖେଳିଲି କିଛି ସମୟ ପରେ ପିଙ୍କି ଆସି ମୋତେ 2ଟା ଚକୋଲେଟ ଦେଲା ଯାହାକି ଗୋଟେ ଧଳା ଏବଂ ଆଉ ପିଙ୍କି ଆଉ ଗୋଟେ ଜରିରେ ଥିଲା ମୁଁ ପଚାରିବାରୁ ସେ ମୋତେ ଅନଲାଇନରେ ମଗାଇଛି ବୋଲି କହିଲା ଏଇ ସମୟରେ ବାଧ୍ୟ ହୋଇ ମୁଁ ସେ ଧଳା ଚକୋଲେଟଟି ଖାଇଲି ଯେତେବେଳେ ଚକୋଲେଟ ଖାଇଲି
cousin sister.
କଜନ ସିଷ୍ଟର ଯେତେବେଳେ ସେ ତାପରେ ମୁଁ ପଢୁ ଯେତେବେଳେ ସେ ପିଙ୍କି ସେ ଚକୋଲେଟ ଖାଇଲି ମୋର ପାଟି ଝିମଝିମ ହେଲା ଏବଂ ମୋତେ ନିଦ ଲାଗିଲା ପିଙ୍କି ଦିଦି ସେଠାରେ ଶୋଇବାକୁ କହିଲା ଏବଂ ମୁଁ ଶୋଇପଡ଼ିଲି ସେଇ ସମୟରେ ଆଉ କଣ ହେଲା ମୋର କିଛି ମନେ ପଡୁନି ମୋର ନିଦ ଭାଙ୍ଗିଲା ବେଳକୁ ମୁଁ ଦେଖିଲି ଯେ ମୁଁ ନାକେଟ ଅବସ୍ଥାରେ ଅଛି ଏବଂ ମୋ ଉପରେ ସଂଗ୍ରାମ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ମଧ୍ୟ କିଛି ନ ପିନ୍ଧି ନାକେଟ ଅବସ୍ଥାରେ ଶୋଇଥିଲା ମୁଁ ଡରିକି ତାକୁ ଧକ୍କା ପକାଇଲି ସେତେବେଳେ ସଂଗ୍ରାମ ମୋତେ
my son has been murdered and due to that we have also committed murder of the victim the person who killed my son that is the case 2 person has been killed lordship case and counter case the fact remains lordship in Durga Puja there was a mela the small shopkeepers were there they have collected some money from the different shopkeepers due to distribution of that money lordship the son of the present petitioner and
eyewitness there
Yes, your lordship. In both cases, eyewitness there in
So let them
prepaid.
be examined.
My lordship.
The petitioner is agreed by the order dated 16/4/2024, whereby his bail plea has been rejected. No, 16/4/2024, bail plea has been rejected. The allegation of the petitioner is so. There are eyewitnesses to the occurrence. Therefore, I am not inclined to enlarge the petitioner on bail. Let me stay without the eyewitnesses being examined before the court. The petitioner is given liberty to review the bail plea after the eyewitnesses are examined. Okay, with this liberty, the petitioner is disposed. Next, 32. Yes.
Petitioner was released on 30/5/2024.
30?
30/5/2024 was on interim bail.
Yes.
My lord, on the ground of son's operation. Thereafter, he has not surrendered. Your lordship.
Not surrendered. Right. What was the order? Which one? The wide order dated 3/5/2023. The petitioner was enlarged on anticipatory bail for a period of
6 weeks.
for a period of 6 months.
6 weeks.
6 weeks, sorry, period of 6 weeks. However, the petitioner has not surrendered and filed the surrender certificate. Therefore, the bail application moved by the petitioner, regular bail application moved by the petitioner is dismissed, and the trial court is directed to issue appropriate process to ensure the presence of the petitioner. Next.
Hon'Ble.
33.
Petitioner custody, my lord. 23/2/24 and 28/2/24, my lord.
28/2/24.
24.
2/24. Okay.
Charge sheet 24/24.
CD is not come.
Offense?
376, my lord.
Call for CD, 1 week. Yes.
34.
May I please your lordship?
Yes.
The petitioner is in custody since 6th March 2024.
6 March
2024.
Yes.
On 29 February 2024, Economic Offences Wing had registered a case against me for the offences under section 420, 468, 471, 120B of the Indian Penal Code.
Right.
I am the co-accused in this case, your lordship. I was serving as an assistant general manager at IDBI Dadanda Mukundapur branch from November 2016 till April 2019. After that, I was transferred as an assistant general manager at Ranchi. Thereafter, the complainant had alleged in this.
Call for CD. Call for CD.
Definitely.
Yes.
Thank you.
35 withdraw. 35 withdraw. Yes, 35 withdraw. 35 withdraw. 36.
36.
May I please, Your Honor?
Yes, sir.
Your Lordship, the petitioner is in custody from 3rd 3/10/2023 for commission of alleged offence under section 376(2)(n) and 6 of POCSO Act.
Yes.
CD is required.
Call for CD, huh? He is 20 years. Call for CD. After 1
Sir,
week. Yes.
please, short date, sir. Say,
After 1 week. 37.
37 on behalf of Mr. Swami, Lord, permit to submit, Lord.
Yes.
Lord, here in this case, Lord, initially the FIR has been lodged under section
Custody
3.
since?
Custody, my Lord.
16/3/24.
16/3/2024, my Lord. Initially, my Lord, 307 and 498 other alleged offence, my Lord. Then, my Lord, after 2 months, that is turned to 302, my Lord.
When the charge sheet was filed?
I have not the charge sheet copy, my Lord.
Date.
Charge sheet is not with him, only CD is with me.
Charge sheet.
Charge sheet is not.
When the charge sheet filed?
My Lord, I have not the copy, my Lord.
Tell me the date at least. Charge sheet is filed subsequent, I think.
Must be filed, my Lord, but I have no instruction about when it is filed.
Till 12/7/24, charge sheet is not there. 12/7/24, because the CD was this CD. 12/7/24.
Or then subsequently charge sheet. Charge sheet has been filed.
No, it is not known. It is not known.
Perhaps not filed because 12/7/24 there is no charge sheet.
Investigation is going on.
You, after charge sheet
Milord.
file, you renew your bail.
Milord,
And the
out.
application, bail application, the petitioner is rejected
Milord,
on
only prayer, Milord.
25/4/2024, and investigation is still going on. And charge sheet has not yet been filed. The petitioner is given liberty to renew the bail plea after the charge sheet is filed. With this liberty, the petitioner is disposed. Yes, next.
38.
Informant note card. Yes.
38.
38. 38, nobody appears. No one appeared earlier also. None appears. None appears for the petitioner. In the interest of justice, urgent.
39. Lawsuit item 39, kindly pass over this matter.
Pass over today may not be possible, sir. You tell me.
Fine.
What is it? Today.
My senior was about to be.
What is the offense? 30?
302 is there, let's see.
To adjourn on request adjourn. Yes.
40.
40. First time.
40
CD is there.
No, Lord, CD is called.
Offense?
302.
302. CD police? Nahin. Call for CD. Call for CD.
41.
What is it called?
Milord.
What I'm going to address. What?
41?
No, CD is
CD is there?
yes.
Yes, 41.
5181.
5158.
5158.
51? 5158. Yes, CD is there.
5158.
No, no, CD.
CD is not there.
No.
My lord.
Call for the CD.
Yes, my lord. It was, there are connected matters, ma'am. And 7920 ସହିତ ସେଟା ଆସୁ
ଯେବେ ଅଛି ସେଇ ଦିନ ପାଇଁ ଲଗେଇଦବ
7920
call for CD so that there won't be any confusion.
ତା ସହିତ କନେକ୍ଟ ହେଇକି 3-4ଟା ଅଛି ମୁଁ ଦେଇଦେବି ସବୁଗୁଡା ଦେଇଦେବି
ସବୁଗୁଡା ଲଗେଇଦବ
ଆଜ୍ଞା ଗୋଟେ ଆରେଞ୍ଜିଂ ଆଉଟ୍ ଅଫ୍ ସେମ୍ ଏଫଆଇଆର
different accused.
ହଁ
Different accused, same FIR.
ଆରେଞ୍ଜିଂ ଆଉଟ୍ ଅଫ୍ ସେମ୍ transaction.
And while coming next time when you come, you give me the role attributed to each. I may reject few, I may allow few. Therefore.
42.
42.
May I please?
Yes, sir.
42 million. 302 CD is required.
Call for CD. Huh? And once call for CD, you make sure that CD comes. Next
Milord,
time,
Milord,
so that
yes.
will not.
Milord, ଟିକେ call for ହେଇଥିଲା ଆଗରୁ ଆଜ୍ଞା ଆଗରୁ ଥରେ ହେଇଥିଲା ଏଇଟା ସେକେଣ୍ଡ ଟାଇମ୍ ଆଜ୍ଞା
No more opportunity shall be given.
Milord.
Yes.
Well, after puja.
We will adjust. Wait. Maybe before puja also. Because I am trying to at least once hear all the.
ହଁ backlog ଗୁଡ଼ା ସବୁ ସରିଯିବ ତାପରେ adjourn ଗୁଡ଼ା
Then adjournment immediately we can.
ଆଜ୍ଞା
43.
ଆଚ୍ଛା
May I please?
Yes.
In this case, notice was issued.
Yes, notice was issued. Anybody is appearing?
Yes, yes.
He's appearing. Okay. Yes. What is the offense?
Offense is made out 376(3).
Okay. Custody since?
Custody since 7th of December 2023.
7 December 23.
Yes, ma'am.
Yes. What are the 164 read?
ଗତ 1921 ମସିହାରେ ମୁଁ ସୋମପୁରରେ ପାଠ ପଢୁଥିଲି ବିଦ୍ୟାଳୟରେ ସେଇ ସମୟରେ ଅଜିତ ଅନାଦି ଦାସ ପ୍ରେସିଡେଣ୍ଟ ପିଟ ଆମ ଗାଁକୁ ଅଛି ଘର ସମ୍ପର୍କୀୟ ଭଉଣୀ ଘରକୁ ଆସେ ତାର ଭଉଣୀ ମାମାଲି ମୋ ସାଙ୍ଗ ଆମେ ଅନାଦିଅ ଦୁଇ ଜଣକୁ ଭଲ ପାଇଲୁ ମୁଁ ଦଶମ ପାସ୍ କଲା ପରେ ବୋରିକିନା କଲେଜରେ ପଢୁଥିଲି ଏଇ ବର୍ଷ ଫେବୃଆରୀ 17ରେ ଅନାଦି ମତେ ଫୋନ କରି ପାଖକୁ ଆସିଲେ ସେ କହିଲା ସେଠାରେ ଖାଲି କଥା ହେଇ ଆସିବ ତାପରେ ଅନାଦି ମତେ ଘରକୁ ନେଇ ଲକ୍ କରିଦେଲେ ସେହି ଦୁଇ ଖଟ ଉପରେ ଶୁଆଇ ମୋ ସହିତ ଜବରଦସ୍ତ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଲା ତା ଫୋନ ଭିତରେ ମଧ୍ୟ ରେକର୍ଡିଂ କଲା ତାପରେ ଆସି ଆମକୁ ସେଠାରୁ ତାପରେ ମୋ ଭାଇ ଆସି ଆମକୁ ସେଠାକୁ ଆଣିଲେ ସେମାନେ ମତେ ବୋରିକିନା ବସଷ୍ଟାଣ୍ଡ ଛାଡ଼ିଲେ ଦୁଇ ଜଣ ସେଠାରୁ ପଳେଇ ଗଲେ ତାପରେ 2 ମାସ ପରେ
Anything recovered? Nude photograph or anything of that.
Nude photograph, my lord.
Just
Regarding
take-
nude photograph.
Item 40 on behalf of Pinny Mishra. I'm really sorry, of the display board.
Which one?
The display board showed.
CD called.
Yes.
My lord.
Yes.
Yes, sir. My lord. One pen drive 32 GB contain 2 numbers of nude video victim. लिखा ही चाहिए.
Sir, thank you to see them, but that are recorded and.
Who has done it?
My lord.
The girl might not have done it.
My lord.
The girl might not have recorded the videographer. You are 23. The girl is about
17 वर्ष की.
you are. This is the perversity of this.
My lord.
You have a relationship, one can understand. Because you have a relationship, you see the perversity is recording.
Thereafter viral.
One prayer, my lord. I'm withdrawing with a liberty to move after examination.
Yes.
Yes.
Land Council, Mr. Divedi, Land Council for the petitioner seeks to withdraw this petition to renew his bail plea after the victim is examined in the present case. The trial court is.
I think summons were issued.
It is expected that.
No, already summons were issued, my lord, for examination.
Therefore, that it is expected that the trial court should do well to see that regard being had to the period of custody of the petitioner from 7/12/2023. It is expected the trial court should do well to see that the victim is examined preferentially over all other witnesses. With this liberty, the petition is disposed of.
I'm for the information.
Informal. I'll just come with 5 minutes.
My lord. Huh?
Six with other allied offences.
Petitions
5424.
5424. Okay.
Yes.
Yes.
Allegation is, my lord, while
CD is
the
there. CD is there.
Yes, sir. CD available.
Tell me what are the.
my lord, except
I am placing the statement of complainant, my lord. A Tilotoma, his category stated. राति प्राय 12:30 समय आमे जीरो नाइट करी सोयाक जाइले এই समय आम घर बाड़ी पछ अगणा रे बोमा फुटिबार प्रचंड शब्द आसिला कोन हला देखे गरा आम गाम ऋषि प्लस एस जगन्नाथ पिटिशन नंबर 1 रवि कुमार पिटिशन नंबर 2 एस लक्षणा पिटिशन नंबर 3 एंड अदर्स सेटा को दौड़ी पळाउछ आमे बाड़ी पाकु जाय देखिलु जे आमको प्राण रे मार देबा उद्देश्य रे उपरोक्त व्यक्ति आम घर ऊपर को बोमा पकाउछंती एवं आम बारीपट कांथ झरका भांगी नष्ट होइछि प्रकाश उपरोक्त व्यक्ति गुंडा प्रकृतिर अटंती आम ग्रामर प्रत्येक लोक मारपिट धमकी दियंती.
my lord, while releasing on bail to the other accused persons, my lord have kind glance
Other
to.
accused persons' names are not there. These you three names.
No, in FIR everybody's name is there. In FIR everybody's
Well,
name.
Show me.
My lord, FIR, my lord have glanced to.
No. Bail order.
Bail order to page 24, my lord, see learned court below is observed except the wall. There is not a scratch mark over the any of the person. 24, my lord.
Yes, 24.
4. Paragraph 5 from 4th line.
From the allegation by the FIR, except the wall, no one hurt and damaged.
See, zero night celebration board ko hai.
Does not seems to be made out.
Yes.
306 then seems to be.
No, 307 million.
307 not seems
Not
to be
made out. That is the observation of the learned court below.
Miller.
Petitioner is accused. Petitioners are accused. Allegations against petitioners. In the FIR, how many accused were?
3 are there.
How many accused were named?
3 named, my lord.
In FIR,
my lord,
12.
The FIR.
Yes.
14, I'm sorry, 14.
14 accused were named. Who are they granted bail?
My lord, granted bail,
While dealing with the bail
P. Mohan
application
Rao.
for one of the co-accused, the Learned Trial Court inter alia observed as under page 24.
not one of my lord, many more, many. Many
While
of the
granting bail to the co-accused. also.
Yes.
Co-accused, the learned court below observed as under invited from the allegation made in the FIR, except the wall, no one hurt or damage. No hurt or damage has been caused to anyone. Prima facie, an offense under section 307 IPC does not seem to be made out. Had anyone of the informant's family being hurt, the severity of the incident could have been worse. Okay. Inverted comma. The petitioners are in custody since 5/4/2024. Regard being head to the nature of allegation and period of custody, the petitions are granted enlarged on bail, subject to verification of the what do you call
Criminal antecedent.
criminal antecedent.
No, they have antecedent. That is, for that reason, my lord,
Whatever. I have given the bail. That's all. Subject to verification.
And our objection may be granted.
Huh?
State objection may be
Objection.
state objection. Yes, sir.
The counsel for the state has vehemently opposed the prayer because in the instant case, the accused persons have used explosive substances and bomb for.
And goon, they are goon character, my lord.
And they have they are habitual offenders. Yes.
45.
Yes.
May I please, madam?
my lord, they have antecedent that is for.
I am not saying anything about that.
5204.
Yes. 6. Subject to verification.
56.
Yes.
My lord, the petitioner in custody since
Here,
19
my lord, what happened, my lord? 1 quintal 20 kg of ganja, my lord. Charge sheet copy, CD with me, my lord. Charge sheet copy not with me.
Learned counsel for the petition state submits that he doesn't have the copy.
Charge sheet filed on 11/7.
1 week adjournment leaves the matter. Yes.
46.
My please, your lordship. My lord, the petitioner custody is 1/12/2023, your lordship.
1/12?
2023.
Yes.
The offense under 498-302-304B, 34 IPC.
My lord,
along
46,
with
my lord. 493-304B CD is required, my lord.
my lord, I have filed
For
that.
CD 1 week. Yes.
57.
Okay.
Yes.
May I please, your lordship? The petitioner is in custody since 1st September 2023.
Sorry?
4th
4th September.
September 2023.
Okay.
The accused petitioner is charged alleged offense under section 498A, 304B, 406, and 4 of Dowry Prohibition Act.
You are the husband?
Yes, lordship.
You are the husband?
Husband.
Yes.
Initially, the
allegation.
Allegation, my lord. Present petitioner demanded dowry, my lord, on the occurrence that they have assaulted the deceased, my lord. Thereafter went away, and thereafter what happened, my lord? When her husband came, my lord, found he was inside the house, my lord. They by breaking the door, entering the house, found his hanging herself in the fan mill.
1 year already.
My lord.
Right. Petitioner is accused. The allegation is it is revealed from the evidence. Form part of the charge sheets that the petitioner has admittedly meted out cruelty to the victim. And on the date of incident, the victim was also assaulted. And however, in the absence of the petitioner, the victim appears to have committed suicide by hanging. Suicide
in the ceiling fan.
Suicide by hanging.
Yes.
Petitioner came home and after breaking the door, entered inside the house. Regard being head to the nature of acquisition and period of custody from 4/9/2023, bail granted. Yes.
48. May I please, madam? The petitioner instead of jail custody since
48 kg ganja CD is required, my lord.
CD call for CD. Yes.
49. My lord,
CD available, my lord.
Prefer only 1 week after. My lord.
On the request of the petitioner and adjourned.
50.
The petitioner is a lady, my lord. She is in custody since 12/3/2024.
Sorry?
She is in custody, the lady,
From?
49 years old, for committing offence under 21B of the NDPS Act for keeping some brown sugar in her house.
Yes.
Her son, only son, who is a polio patient or handicapped, he is a habitual offender, habitually taking that drugs. That's why it was found from her possession below commercial quantity.
Custody since?
12/3. 12/3/2024. Charge sheet must have been submitted, my lord. And it is below. There is no criminal entity.
Yes, 170 gram of brown sugar, my lord. What CD is required? CD.
CD was called for way back in
But
20.
see the lady.
Lady, lock that out, lady.
There is a polio patient.
That I have not.
Son is a polio patient. Son is a polio who is the habitual.
Next week,
taking
let's
that.
often CD.
Next week, immediately.
There is absolutely no.
Next week, Wednesday. Because
Next
she just check it up.
Miller.
She is a lady, no doubt. If there is a son who is a polio patient,
Yeah, I get
grant bail.
She is the only lady prisoner there.
Wednesday. Yes.
51.
May it be also on behalf of Mr. Ponda Lordships. Your Lordships, 376 2N.
Yes.
Petition is custody since 2/3/2024. Lordships.
2/3/2024.
2024.
Yes.
Victim age is 21 years.
Yes.
And petitioner age is 30 years, Lordships. So I am perusing the 160.
ଆମ ଘରକୁ ସେ ଆସିଲା ମୁଁ ତାକୁ ମନା କରିବା ପରେ ବି ମୋ ସହ ଜୋର ସାରିକି ସମ୍ପର୍କ ରଖିଲା ଗତ 17/2/24 ତାରିଖରେ ମୁଁ ମାମୁଁ ଘରକୁ ଯାଇଥିଲି ଆଉ ସେ ପିଲା ତାର ଖବର ପାଇ ମୋର ମାମୁଁ ଘରକୁ ଆସିଲା ଆଉ ୟେସ୍ no sign of symptom or recent sexual.
Right. Petition is accused in FIR number 2. The statement of the petitioner, who is statement of the victim, who is what is the age?
21 years.
21 years of age has been recorded by the police under section 164 CRM. She in her statement interior stated that the petitioner has committed sexual. The petitioner has kept sexual relationship with her with a promise to marry. With a promise to marry. I have perused the medical evidence. It reveals from the medical evidence that there is no recent sexual sign and symptom of sexual intercourse. Regarding head to the fact that the petitioner is in custody since 2/3/2024 and nature of accusation. You are writing accusation from you. Wherever I give the dictation, accusation, he every time he writes that accusation, ACQUIS, every time. I'm saying what is the difference between this accusation and that accusation?
A type of error.
Okay. And that happens because in the computer, if you check that accusation,
right.
click yes. And while reading it, is invariably I get that escape. Yes.
Well granted, Lordships.
Yes.
May I please, Lords? Petitioner is custody since 10/1/2022, my lord.
10/1/2022.
2022. And charge sheet submitted on 31 March 2022 for the offence under section 302, my lord.
Yes. Yes, charge sheet is there.
Milord, charge sheet available. What happened in this case, Milord? I have received only charge sheet copy. Here, Milord, son, Milord, killed his father because son assaulted his wife, Milord. While father interfered and tried to rescue her daughter-in-law, Milord, President petitioner assaulted his father by a stick. As a result, he died on the spot, Milord, due to head injury, Milord. That is in FIR story. That is clear, Milord.
Case
And
is that,
his Milord mother is also eyewitness. His wife is also eyewitness, Milord, to this, Milord. But 116 statement are not available, Milord. Only charge sheet copy.
Bring this in.
Only charge sheet.
Madam, what happened, my lord? There is a quarrel between husband.
Whatever he has said, according to whatever story he is saying, you are entitled to bail.
My lord.
Let him bring 161, I grant.
Milord.
Okay. After 1 week,
You want it, Milord.
CD, let the CD come. Because it is a case of single blow.
304B. It is a case of maximum 304B. my lord.
Single blow, head injury, Milord. Single blow, but multiple.
By the son.
By the
father.
Yes.
Because
father want to rescue her daughter-in-law, Milord. He is assaulting her own wife, Milord.
That time the father came.
No.
Yes. I know the accused was beating his wife. Father-in-law intervened.
Yes,
He gave a blow and he died.
Yes,
That's the story.
that is the case, Milord.
Let us see.
Case of maximum 304. My lord.
Next.
53.
Withdraw. Yes, withdraw. Yes. 54.
54.
53, Milord.
Withdraw. 54. Yes, sir.
54.
My lord, a notice was issued on the last occasion.
You should just see the service.
Notice is sufficient.
Yes, Milord.
Service.
Notice sufficient.
Confirmation letter available, Milord.
Huh?
Confirmation letter available, Milord.
Okay. What
Notice
is
for
the-
one victim.
What is the reason?
376 is there, POSCO is there. The 164 statement of the victim, I will give to my lordship.
You accept a rejection order, you have not filed anything, not even the FIR. What kind of petition? You are keeping everything for yourself. You don't want to give it to the court.
15 years.
You have everything for you, you are not filing.
এটা পরে আজ্ঞା ଇଏ পুଲିସ ପେପରଟା ପରେ ମିଳିଲା
15 years girl, Milord, is pregnant, Milord.
ଆଜ୍ଞା ମୁଁ କହିଦଉଛି କଣ ହଉଛି ପ୍ରୋବ୍ଲେମ
Do one thing, you file this document, I will put it next week.
ଏଫଆଇଆର କପିଟା ଯାହା ଆମକୁ ମିଳୁଛି
Wait, at least something should be there on
ଆଜ୍ଞା
record.
ଏଇ ଏଫଆଇଆର କପିଟା ଯଦି ଆମେ ଅନଲାଇନରେ ଫାଇଲ କରିବୁ ଟିକେ ଯଦି କୋଉଠି ରହୁଛି ଦାଗ ପଳେଇ ଆସୁଛି ଡିଫେକ୍ଟ ଆଉ ନମ୍ବର ହେଇଥିବ
164 statement to file karo.
ଏ 164
File it, I am taking it up next week.
Milord.
କିଛି ନାହିଁ ଭିଣେଇ ଆଉ ଶାଳୀ
28 years.
ଭିଣେଇ ଶାଳୀ
He is 15 years old victim, Milord. And his unwanted mother, Milord. He is pregnant.
He is married, this boy.
Yes. ତା ଭଉଣୀ କି ବାହା ହେଇଛି.
Wait, file this.
Yes.
This is exploitation. You are married? You
ନା
are
ଶାଳୀ
exploit-
ଭିଣେଇ ପରା ଆଜ୍ଞା
Whatever.
ମନା କରୁଛି.
Whatever. See, there is a difference between, I was telling in the morning, there is a difference between exploitation and relationship.
Milord.
If you are 28-year-old, you are married, you are keeping a relationship with a minor girl, then it is exploitation. For that, you are not entitled to be. If you are unmarried, you have a relationship, it is not exploitation. This is natural between
Milord.
the two same age group persons. So therefore, I am granting me.
ସେ 164 କହୁଛି ଯେ ଆମେ
You are married, then no question. You knew that you are married, you are exploiting a child. This is exploitation.
I will file it.
So therefore, under POXO, you are not entitled. You file it
Well.
after 2 weeks.
Well.
After 2 weeks.
55.
55.
On 20 we close to close here NDPS Act man and
Yes.
custody since 4/5/2024 man lord.
4/5/2024
man lord.
Yes.
46 kilo ganja seized platform number 2 of Barampur railway station.
6 kg, my lord.
Platform number 2 of
CD is not there, but I have taken.
Call for CD after 2 weeks.
my lord see charge sheet already filed man.
Call for CD because I will grant bail, therefore CD has to be there.
Only
And
sorted.
the record it should be there.
Sorted.
Huh?
56.
Call for CD, least after 2 weeks. Call for CD, huh?
My lord.
56.
May I please?
Yes.
Same co-accused man.
56, co-accused. Call for CD, huh? Least both the matters together. Yes.
57.
May I please? My custody since 5th January 24.
5th January
24. Charge sheet submitted 498/306. The wife committed suicide, bolting inside from the house.
Show
There
me.
is a quarrel.
Show me that. Show me.
I am read out the statement, my lord, of one Sarada Bhoi. ତାର ସ୍ତ୍ରୀ ମଧ୍ୟ ନ ଖାଇ ରୁମ୍ ଭିତର ଅଲଗା ଖଟରେ ଶୋଇ ପଡିଲା। ତାର ପୁଅ ପୂର୍ବରୁ ଶୋଇଥିଲା। ସମୟ ପ୍ରାୟ 3 ଘଣ୍ଟା ହେବ। ମୋର ନାତି ଉଠି କାନ୍ଦିବାରୁ ମୋର ପୁଅ ତାକୁ ଧରି ରୁମ୍ ଭିତରୁ ବାହାରି ଆସିଲା ଓ ତାର ପୁଅ ବାରଣ୍ଡା ଛାଡି ଘର ବାହାରକୁ ଆସିଲା। କିଛି ସମୟ ପରେ ସେ ଘରକୁ ଫେରି ଦେଖିଲା ଯେ ତାଙ୍କ ରୁମ୍ ର କବାଟ ଭିତର ପଟୁ ବନ୍ଦ ଅଛି। Subject to similar antecedent.
Whatever. Petition is accused on so and so, allegation against the petitioner so and so. The statement of the witnesses recorded under 161 CRPT was read out extensively at the bar, which it reveals from the evidence which form part of the record that the victim girl has victim with the wife of the petitioner has committed suicide inside the room, bolting the door from inside. The door was broke open to rescue her. However, she succumbed to. However, she died. Regarding her to the nature of acquisition and the period of custody from 5/1/2024, granted, subject to verification of both the
Similar antecedent. Hon'Ble.
May please, Your Lordship.
306.
Call for CD.
May please, Your Lordship. Your Lordship, the offence alleged are 417 and 493.
Yes.
Your Lordship, the offence alleged are 417 and 493.
This is which item?
58, Your Lordship. 8.
Yes.
As a custody since 31/3/2024.
31/3.
3. Yes, Your Lordship. Charge sheet submitted on 24/5/24.
24/5.
Yes, Your Lordship. Both the informant and the petitioner has consensual physical relationship, Your Lordship. In fact, the informant is a married lady, concealed her identity as a married status or marital status, and kept physical relationship with this petitioner. And there is no symptom and the medical report silent about any physical relationship, Your Lordship.
Yes.
My lord. My lord, the medical report is that find that suicidal hanging, my lord. But there are two.
That is not
161
the case.
Let me.
This is not that case.
161 statement is there, my lord. I may be.
His husband. His husband.
Yes, my lord. This petitioner is husband, my lord.
Yes.
Oh, no.
My lord, I would like to read the 161 statement of one of a labor, my lord.
Which case he is holding?
He's arguing your matter.
No. I have cases on 417 and
My lord,
493.
one item disturbed, my lord. For which, my lord, today morning also I have received one copy with 5 items. My lord, 58, my lord, 306.
I just check it up.
No, 58.
Sukanta Kumar Mahapatra. Accused name is Sukanta Kumar Mahapatra.
50. 58.
Sukant Mahapatra.
Sukant Kumar Mahapatra, my lord. I have submitted, my lord, 306 matter. CD has not.
CD. Call for CD. Call for CD.
Yeah.
Up convict. Yes.
Your Lordship, 58, not 306, Your Lordship.
Wait, please, Your Lordship.
I am
Your
calling for
Lordship,
CD, sir.
Your Lordship, this is not a 306 case, Your Lordship. This is 417 and 493.
Just check it up.
This matter happens to be
58 is 5325.
5325 Sukant Kumar Mahapatra, my lord.
He says that what? Let us see the open.
Let's see, Your Lordship, kindly see the FIR, Your Lordship.
No, my lord. Sorry, my lord. 417, 493, 294. My lord, sorry, my
Yes.
lord. Pardon.
Yes, no problem. Yes. Shall I put it next week?
Yes, my lord.
He has not seen the CD and all. I'll put it next week. Okay.
Your Lordship, they are in a consensual relationship.
Try to understand. See, there is some confusion. They could not, study it. next week.
All our master table offences are where I am in custody since March, Your Lordship.
I am putting it, let it be Wednesday, let it be.
Yes, grateful.
My pleasure, Lordship. Lordship, the petitioner is in custody since 2/2/2024, Lordship.
2/2/24.
Lordship. Lordship, initially the FIR was lodged under section 294, 302, 304B, 34, 498A, and 4 of DP Act.
Yes.
Subsequently, Lordship, charge sheet has been filed.
When charge sheet filed?
Lordship, charge sheet filed on 21/5/2024, Lordship.
Keeping in
21/5.
Yes, sir, Lordship. 21/5/24.
Then you should go, now the charge sheet is for which offense?
Lordship, 498A, 304B, 34, 306.
302 is dropped.
Yes, Lordship. It has been converted to 306, Lordship.
Okay, right. Petitioner is agreed by the order dated 16/5/2024, whereby his bail plea has been rejected. Initially, the FIR was registered for alleged offence under section 294, 302, 304B, 34, and 498A. Read with section 4 of DP Act. After investigation, charge sheet has been filed on 21/5/2024. In the charge sheet, the offence punishable under section 302 IPC has been dropped. In view of the changing circumstances, petitioner may approach the court of first instance, renewing his bail plea. With this observation, the petition is disposed.
Lordship, in the charge sheet, it has been categorically stated that the cause of death is asphyxia and venous.
Therefore, you go.
Yes, sir.
Yes.
Your Lordship, that two lady member of one family are in custody since 9th April 2024.
9/4/2024. Okay.
The offense originally registered under section 307, later converted to 302. The
Yes.
quarrel,
Yes, my lord.
Yes.
quarrel arises out of a killing of a chick.
Suman Gowda and Sanai Gowda.
My lord.
What are the?
My lord, I would like to submit before your lordship one of
the
a
assailant.
eyewitness statement, my lord. The relevant part, my lord. The हठात मोर स्त्री पार्टी शुणी मुझे देखियो जानि पइल आम घरे पाळीथिबा गोटे कुकुडा छुआ आम सामना घर संजीव गौडर घर को पसि जाइतिला तापर संजीव गौडर झियो सुमन दिस पिटिशनर गौड लात मारी कुकुडा छुआ को मारी देइतिला मोर स्त्री जतले ताको कोन पय कुकुडा छुआ को मारिलु बोली कहि पचारिबारु संजीव गौडर स्त्री सनाई गौड संजीव गौडर झियो सुमन गौड दिस पिटिशनर घर बाहर को आसी तुम कुकुड़ा आम घर भर कहीं पशु कही मो स्त्री सहित गाली गलौज कले मो स्त्री कुकुड़ा छुआ मारिबार क्षतिपूरण मागिबारु सेमाने समस्ते मिसी मो स्त्री की मारपीट कर झगड़ा कले जेतेबेले मु मो स्त्री को छड़ाइबा पई जाइतिली मते भी मारपीट कले एही समय मोर बापा रवि पत्र मोर भाई मनोज पत्र आसी ताको बुझाई कुकुड़ा छुआ मारिबार क्षतिपूरण मागिबारु देबु नाही जा करिबार अछि कर कहि अभद्र भाषा गाली गलौज करथिले एति भितरे संजीव गौड़ द फादर ऑफ दिस पिटिशनर रागी की आसी सामान्य कुकुड़ा पे मो स्त्री पिला सह झगड़ा करुचु कही मोर बापा रवि पत्र को ठेला पेला कले मो भाई मनोज पत्र कौन पे मोर बापा को ठेला पेला करुचु कही ताको छड़ाइबारु संजीव गौड़ तले पड़ी जाइथिले एतिकी बेरे संजीव गौड़ रागी जाई तार स्त्री सनाई गौड़ ओ संजीव गौड़ झियो सुमन गौड़ दिस पिटिशनर ओ सुनील गौड़ दौड़ की आसी मोर बापा और भाई को मोर मारपीट और ठेला पेला कले झील पिला भाई कहीं एमती हौच कह शुणिले ना तापर संजीव गौड़ रागी कुटी तार घर पाखे गोटे काठ पाଳି आनी मो बापार मुंड को मारिदेला बाड़े आज्ञा संजीव These
are the two girls. They
were
participated.
Participated with the dispute.
Lady member.
My lord.
Petition. Is a fit of phrase this has happened. There is no pre-planned cold-blooded murder, and it's a case of a single blow. And the lady member in the this thing family, they have not restored.
My lord, this lady has only killed the chicken cheek, my lord. But his father, her father has assaulted and ultimately.
Out of fit of phrase.
Yes, my lord.
Because the lady member.
Yes,
right. Petition rejecting so. Allegation against the petitioners are like so. The petition number, the eyewitness count in the present case recorded under section 161 CRPC reveals that there was a quarrel taken place between the petitioners and the deceased on a very silly matter, in a silly matter. There was tug of war between the petitioner as well as the petitioner and the deceased. At that point in time, the father of the petitioner number 1 and the brother, both of them reached the spot, and out of a fit of rage, gave a lathi blow, na?
Yes, my lord. Kathaphalia, wooden plank.
Wooden plank. Gave a blow in wooden plank at the head of the deceased, to which the deceased succumbed. It is also revealing from the evidence that the present petitioner, being the lady member of the family, have petitioners, the lady being a member of the family, have not committed any overtake causing injury to the deceased. Injury to the deceased. Petitioner is petitioner is a girl of 20 years of age, whereas the petitioner number 2 is 42 years of age, who is the mother of the petitioner number 1. Petitioner number 1. Since the entire
161 statement disclosed that Pittamara Kole.
And the entire allegation as germinating from record reveals that it is the father of the petitioner number 1 and the husband of the petitioner number 2, Sanjeev God, has given the blow which has resulted the death of the deceased. In view of regard being had to the nature of accusation against the petitioner and the fact that the petitioners are lady members of the family, they are in custody since 9/4/2024. I am inclined to enlarge the petitioner on bail accordingly granted bail.
61. 61, my lord, CD.
call
302.
CD call for 62.
62 also same, my lord.
CD call for.
Will permitted to withdraw.
Withdraw.
In this
Then
month,
call for the petitioner seeks to withdraw the petition. Yes. 63.
My lord, CD may be called.
CD.
Yes, my lord.
63 CD.
64.
May I please, your lordship? I am appearing on behalf of AK Visway, lordship.
Hmm?
I am appearing on behalf of AK Visway
Yes.
in this case, lordship. The petitioner is in custody since 5/3.
5/3.
21/5/2024.
21.
5/2024.
Yes.
In the alleged offense under section 498, 306 and 34 of the IPC, lordship. Lordship,
CD.
I am
My lord,
appearing for
CD
the
is there.
informant lordship. In this case, the matter has been settled. I have filed an affidavit. Flag C, your lordship, can glance for
Affidavit, one of
Flag
affidavit.
C. The present informant
the
is the brother
informant.
of the deceased. Informant is the brother of the
Informant.
deceased.
Yes, but
And matter.
My lord, but the postmortem report is regarding the
Hanging.
suicidal, my lord. But
Because
the
hanging
torture and
asphyxia.
cruelty part is there according to the
but
160.
they the informant is wriggling out of the
Yes, my
because
lord.
of the-
And his son has also stated regarding the torture from his father.
Asphyxia.
Right now, petitioner is accused in so and so case. Allegation is the petitioner so and so. When the matter notice was issued,
No, lordship,
notice was
by
issued
bringing
to,
the knowledge to the
opposite
filing.
party number 2, the informant in the case. After entering appearance, the opposite party number 2 has filed an affidavit, inter alia stating as under. Para 3 affidavit page affidavit
C.
flag C.
Yes, sir.
Flag C para
Paragraph
2,
clear.
3 and 4.
Yes,
Para
sir.
3 and 4. 3 and 4. The petitioner is in custody since 21/5/2024. Regard being held to the period of custody and the fact that the informant is not supporting the prosecution by filing the informant has filed an affidavit virtually revealing out of his earlier statement. I am inclined to enlarge on petition on bail accordingly. Yes.
Obliged.
Yes.
65.
65.
Petitioner is at the jail custody since 21st April 24, my lord.
21st?
For 21st April 24, my lord.
Yes.
11 grams of brown sugar seized from pocket of another person.
Yes.
Co-jointly, my lord, co-jointly, both were moved
Kindly
jointly,
Antecedent?
and it has been seized from there, my lord. Of course, the seized brown sugar is
11 gram.
11 grams from the pocket of a Soumya Ranjana Naik.
small quantity and less than from commercial quantity. But my lord, one thing is there, my lord. Both the accused persons having this petitioner, my lord, Parsuram Dhir, my lord. Parsuram Dhir having four criminal antecedents.
I will not say.
Comprehensive affidavit, my lord.
I will not say anything.
Similar nature, my lord.
Whatever.
Or any other offense, my lord.
Other offense.
The accused so and so. Allegation, you know.
Well, filing.
Recovery is 11 grams, which is less than commercial quantity. He is in custody since 21/4/2024.
Recovery from Soumya Ranjana Naik, not from the petitioner, my lord.
Okay.
Not in similar nature, my lord.
I will not say anything.
66.
Let it be verified. Subject to verification. 50? 66. Yes, sir.
For petition 380, so far the petitioner is concerned, it is 413 of the Indian Penal Code.
Yes.
The charge sheet has been filed, the petitioner is a.
It is there?
Yes, my lord.
Yes.
The petitioner is a Kawadiwala, and he is alleged to have purchased some articles after commission of the theft. What happened in this case?
Custody since?
Custody, my lord.
Remand dated 17/5/2024,
my lord.
मेन केस रे बेल हे गलानी जो तेरे प्रथम सीजर हला हाई कोर्ट देला पर से कोन कले जत्ते अननोन केस थला सब थे टैग करि पकेले so दीटा केस हे सलानी
But my lord, the criminal antecedent is there 25 CR.
मोर मने पड़ जो मतलब नुआ नुआ उकलाती करथली डकाइत केस रैंपट होतला अननोन होतला गोटाई थाना जहा को धर देले ताको तरी सब थरे टैग करि पकेले
यदि पेंडिंग केस सब रिमांड
ये मूल केस रे बेल हे गिरी गलानी हाई कोर्ट दे
how many in
25 and 25, my lord.
Even if you get the bail, you must be in the custody. In this case, you get bail. In the other case, they'll take custody.
I'll
They will not allow you to come out.
I'll chatta achi.
In this case, my lord, the stolen property from the temple, my lord, it has been recovered from this petitioner.
अरे यार देर किसी रिकवरी है निजे मूला केस रे जब्त कले सब देर
कौन रिकवरी 311 411 411
413 habitual receiving stolen property.
Okay, 413. Yes. Sentence? What?
No, तादरे 413 नहीं, चार्ज शीट रे नहीं, चार्ज शीट रे 380.
380.
फिर से समस्त बेल रे गले ने.
Subject to verification of antecedent.
Okay.
Subject to verification of Subject to verification of antecedent, I am granting bail.
Verification माने?
The other, how many
Out
cases?
चार्टा 80 अच्छी हाई कोर्ट रे पेंडिंग अच्छी.
Then all the matters, let all the matter come, I will consider.
हाँ जे स्टाबी कर दे वैसे चार्टा को लिस्ट.
Give the number. Let all the matter be.
My lord.
Better अब.
Let all the. See, this has been a practice. That's the whole difficulty.
25 numbers, my lord.
25, maybe 30 also.
अरे गोटाई केस रे जब्त करी कि जते केस तला सब लगे देबो केमती होबो.
And you solve. I want to see when the FIR were registered. I'll see the
No,
date
it's
of FIR and subsequently I'll just check it. Therefore, all the four matters released. And you prepare a chart, the date of FIR and arrest in that case, the original case, and let us see whether the FIRs were prior to the
से कौन हला से केस रे अरेस्ट हला जेमति बेल हे गेले हाई कोर्ट दे देले अन्य केस गुटे गुटे लगे देले कोन
the date of FIR, let us coordinate.
I will mention all the cases when registered.
Prepare a chart and
This.
Next week
all the four matters. 67. 67, yes, sir.
Your Lordship has already had the matter.
Huh?
Your Lordship has already had that matter.
Oh, I forgot. Tell me.
My Lord, one. My Lord, the case.
How many cases?
My lord,
In
my lord,
three cases.
my lord,
Three cases.
may I submit one thing, my lord? My lord, this two connected cases are two petitioner, my lord. One is Ramesh Chandra Padi, and another one is Lakshmi Narayana Das. And your lordship has directed accordingly, your lordship's direction, the 5 files today come together. But due to the wrong
shall I put it
assignment,
next
today
week?
morning I have received the
Shall I
file.
put it next week?
Yes.
Hard time again.
Right.
My lord, there are my lord.
File put
No, no, my lord. There are crores of rupees.
No, crores of rupees.
Draft list में लोग separate हो जाता है.
सब तो फाइल अच्छी
Final list. But then-
My lord, it is come with the weekly.
Let us not waste time. Next week.
नेक्स्ट महीना बुधवार बुधवार नहीं बुधवार दिन आगे पूरा 3 थर आर्ज में मंगल हां
Thursday because because Wednesday there are a lot of matters. You may not reach Thursday. Okay. Prepare the chart and give Mr.
Yes,
okay. Yes.
देखिए सर
Okay. Compromise matters.
मैडम मैं प्रेम लड़ यो लर्सी में डायरेक्ट ऑल द मैटर विल लिस्टेड मैडम
All the matters are
ना सेटा डिफिकल्ट होची गोटे रे ऑर्डर हे जाउची आरो गुडा भारी कष्ट होची आने
let all the matter be listed. All the matter. All the matters.
लिस्ट दिस मैटर एलिंग विथ ऑल कर दल फास्ट आसे तो हे जो
नहीं ऑलरेडी चार्ज मिस्टर त्रिपाठी
ना हो नहीं आगे मु हैरान हे बोली मु कहू छ नल काई कोइ
Make sure you will list.
ऑलरेडी टैग
Yes.
86 May, please, ma'am.
Yes.
Already, joint affidavit has been filed. Well,
86. Yes.
informative.
I'm appearing for informative lot.
What are the offenses?
376.
376.
SDGM Dharamgarh.
Condition.
Condition, Lordship.
Which condition?
Condition C, page 19.
19, huh?
Running page 19.
19.
6. Yes, Lordships.
Yes.
It is order dated 14/2/2023.
Yes. Which condition?
Condition, they shall appear before the IO on each Saturday till submission of FAQ, Lordships. Final proof.
You appear, what is the problem?
Lordships, till date, since 1 year, till date, he is not.
1 year you have been appearing.
I am appearing, Lordships.
Till date, as and when required. Which conditions?
C, Lordships.
C, condition number C, page 19, modified. Modified to the extent that as and when the petitioners are required to appear before the IO.
For the purpose of investigation.
Huh?
For the purpose of investigation.
For the purpose of investigation, they shall appear before the IO. Appear before there. With this modification, the petition is allowed, and rest of the condition imposed by the court by the order dated, impure order dated 14/2/2023, 14/2/2023 remains same. Yes.
Condition C, Lordships.
C is modified as and when required. Yes.
69. Question of cognizance.
Cognizance.
417.
Opposite party number 2. Anybody appears?
No, my lord. Return answer with the postal address.
Address moved and returned to center. Address moved and returned to the center.
The notice could not be issued to served to the opposite party number 2 due to want of press address. Press address, na?
What happened?
As he has left, he has or she has? She has left the address address given. She has, na? She has, na?
She.
Address he has left the above, and therefore the petition is directed to press press address and serve.
Item 70.
70 is here.
Yes.
It is a challenge the order dated 29/9/2022.
No, 1 minute, 1 minute. 69, yes, Mr. Lenka, you are appearing in 69.
My lord, I am seeking adjournment, short adjournment.
No, I have already adjourned because see, the respondent could not be served. You have to give fresh address.
Lordship, as per my instruction, the opposite party married another place, and as per
Whatever
their
you
council.
give the fresh address, I am adjourning. Okay.
Okay.
Item 70.
Here challenging the order dated 29/9/2022 passed by the 11th additional session judge Malatha.
Yes.
While the evidence is closed by the trial court, my lord.
Where is that order? 29. Yes.
That is your lordship, annexure 2.
The revision order.
Your lordship,
Yes.
3/6/2022.
Yes. Prime party.
Advocate for the complaint is present, accused absence, but repented on the 317 CRPC.
Where are you reading? Where are you reading?
I'm page 15 annexure 2, my first order passed by the Lord James.
Yes.
I have not filed a petition for adjournment because I have filed the petition on 317 CRPC. That is defense evidence closed on that date. I have filed a petition for recalling.
What is the offense?
138 NI Act.
You are accused.
Yeah, I'm right. So defense is on very same date. Defense.
Notice was issued.
No notice was.
Notice has to be issued.
Yes.
Issue notice 1 week after. Yes. Issue notice 1 week after. Lela, give one more chance.
Yes.
Yes.
71.
May it be to us. Well, let me kindly see the order passed by this Hon'Ble Court in this case on 24/11/2022.
23/11.
24/11. Order number 1.
Yes.
Well, let me kindly see.
Yes.
The entire facts and everything has been written. And direction was given to my lord and friend after the instruction.
The notice also, my lord, issued to the opposite party, my lord.
Why?
The I
No, state only.
No,
Accused who can notice you.
Notice sufficient.
Fact that, my lord, on basing upon my allegation, case was registered, accused was arrested, and ₹1 crore, my allegation that he has taken 1 crore in the name of Pandian, that I am related to Pandian. So pay me this amount so that the work will be done. And accordingly, he has taken.
You had taken.
No, he has taken. Accused has taken. I am the informant.
Who are you? You are the informant.
My lord.
Yes.
And accused was arrested and 20 lakhs has been seized from him. I said, in between the investigation has been completed and charge sheet has been submitted against the accused.
That 20 lakhs you need it.
My money, my lord, at least some amount in due surety. My lord, whatever surety they quote.
Yes, what do you say?
But since, my lord, they
court says after trial only you can get it.
My lord, initially they filed application.
What are you doing, by the way?
My lord, I'm a businessman. So
What
belongs to Jharkhand. Belongs to
Initially they filed an application before the concerned court, my lord, for understand for petition CRPC, my lord. That has been rejected.
After by, let me complete it. After the application of before my state was rejected, I filed a revision before the Lawrence Session Judge. That application was also rejected. Again, after submission of charge sheet, I draw the attention of the magistrate by filing an application. Lord Magistrate was pleased to reject my application that once the application has been rejected in criminal division, So I should
I
not.
can't entertain.
And one objection made, the money will remain with the court till submission of the completion of trial. For that reason, matter I have not passed an order since a higher manner the court party order.
This court is higher than.
No, no, since sessions court, my lord.
I understand it.
For that
The
reason,
magistrate could not have done it
No, no.
because there is an
And
observation
against
by
that,
the
yes.
Supreme Court.
Everything is written, my lord. Why? For in the initial stage, I said. My lord,
What
this
you,
is-
what surety you want to give?
Anything, my lord, court will pass.
You
Direct.
tell me, I'll put it to
Proper,
them.
a property security, any bank guarantee, I can give.
What kind of work you wanted to get it done through this man?
That some supplier, that is there in the affair. I have made it clear in the affair. Let me kindly
How much you give? 1 crore you have given. How much you have given?
1 crore.
So 1 crore.
You have given.
But 20 lakhs recovered.
Man from Chhattisgarh.
You are from Chhattisgarh. So you can't give property security also.
Property, bank guarantee, ballot message.
Bank guarantee give. Let him take the bank.
Jharkhand, sir, Jharkhand.
Businessman, he can. Why his money will be stuck in a businessman? Bank subject to furnishing bank guarantee and indemnity bond. Release.
Indemnity bond.
Right. Petitioner.
The resident of Jharkhand.
If you notice to
Lobo.
In this petition is assailing the order dated.
Order dated.
Order dated 16/9/2022 passed by Lieutenant SDGM Bhubaneswar in PMC number 497 of 2022 arising out of CT case number 2019 of 2015, whereby his application under section 457 CRPC has been rejected. The petitioner had approached the court of SDJM Bhubaneswar by moving an application for release of the release of rupees 20 lakh seized from the accused. However, the court below rejected the same. On
Paragraph, one page 33, paragraph, second paragraph.
Rejected the same on the ground. 33, na?
Ballot.
Page
On
33,
page 33.
second paragraph.
Peruse the case record.
On the ground that the petitioner had earlier approached the trial court for the same relief, which was turned down. Thereafter, he had approached by the Court of Additional Sessions at Bhubaneswar by filing criminal revision 24 for 2015. After having the criminal revision rejected, again the petitioner has approached the court of SDGM. Therefore, the SDGM expressed inability to allow the application.
As because in the revisional order.
Because in the revision order,
it seems that
there is a revision order. The revisional court
Observation of the Lord
has
observed.
Entirely observed, inverted comma. It seems that the cash up to 20 lakhs has been deposited in proper head of accounts of the government. Full stop. The petitioner is to wait till the conclusion of trial. In view of the observation made by the revisional court, the trial court has rightly rejected the application under section 457 CRPC. The petitioner is agreed by the same and invoked the jurisdiction of this court under 482 CRPC. 482 CRPC. उसके बाद ये order dated 24/11/2024. Para 4. Para 5. Para 4 or 5. Mr. Ragada, the counsel for the state vehemently opposed the prayer and submits that no fault could be found from the order up to the impugn order. No fault could be found from the impugn order because the petitioner has repeated the prayer under section 457 CRPC before the trial court, having his revision petition already
Another matter,
dismissed.
they have not challenged the order of revisional court.
And he further submits that the petitioner ought to have challenged
Should have.
the order passed by the revisional court instead of approaching the trial court once again. Be that as it may, I am of the considered view that the jurisdiction of this court under 482 CRPC is not precluded to examine the peculiar, examine the issue which is peculiar, examine the issue in the peculiarity of the situation. At the Mr. Dhar, learned counsel for the petitioner at the outset submits that he is ready and willing to furnish appropriate security if security towards the release of the
Bank guarantee.
release of the cash seized from the petitioner. Regard being had to the aforementioned, I am in agreement with Mr. Dhan. Accordingly, the trial court is directed to release release rupees 20 lakhs in favor of the present petitioner, subject to petitioner furnishing equivalent bank guarantee and indemnity bond. With this observation, the petition is disposed of. Yes.
72.
Appearing to VC. Lordship, on behalf of my landlord, I pray for a passport.
Sorry?
Lordship, I pray for a passport.
No. Pass over at this stage. I don't know. At request, adjourn.
73. Both case minutes arising out of one.
73 also.
Am I audible, Lordship?
Yes. 74.
74, may I speak, Lordship? I'm challenging the order of cognizance by which the learned trial court has taken cognizance under section 498A, 109 and 34 IPC and 4 DPI.
What are the grounds, sir?
Ground Lord, first the 498A 4 defect not acted against the present petitioner. Because Lord, the one Kudrat Ali Khan married the present opposite party earlier. After divorce has been made, they married the present petitioner. Second, my Lord, your Lordship can have glanced the FR itself. I have annexed. Lord, first the earlier FR.
You are the second wife.
Yes, if your Lordship can have glanced the FR itself. My Lord, first the present opposite party.
1 minute. Notice is served?
No.
Huh?
Delivered.
Notice, sir.
Notice already.
Yes.
If your Lordship can have glanced the FR itself, my Lord, first earlier the present opposite party filed lodge FR before the superintendent of police railway, and
Show me the charge sheet. Show me the charge sheet.
I have already filed the charge sheet, my Lord. It is in the record.
Show me the charge sheet because you are challenging the cognizance order. Let us see the charge sheet. Yes. Come to the charge sheet. 120B is also there.
109, madam.
109.
Charge sheet filed against this petitioner.
109.
109, 34 and 498, madam.
Yes, 109, 34. Both of the offences are directed towards you.
Sir, my Lord, kind of plans, your Lordship, annexed it's my FR itself. My Lord, first
Sir, forget about FIR. Charge sheet has been filed. Read the charge sheet. Case is made out or not. Cognizance has been taken on the strength of the allegation in the charge sheet. If something is made out against you, then you have to face it or go and argue at the stage of framing of charges.
But Lord, your Lordship issue notice, but nobody appear in this case, Lord.
That doesn't mean that I'll quash it. I'll have to apply my mind whether any case is made out or not. Just see, check it up.
161 statement, my Lord, one of the witness, my Lord. तार नाम पुष्पांजलि साउदी पिटिशनर से पुलिस जीआरपी रे काम करूची से भी पुलिस जीआरपी रे काम करूची एबे से प्रेग्नेंट अछि बोली आमे सुनुछु तार निकानामा होईची कुदरत अली रो मां बापा भौणी माने पुष्पांजलि को बहु भाव स्वीकार करछि पुष्पांजलि एकाडे
ଏଠାକୁ ଆସିଥିଲା ମଣ୍ଟୁ କୁଦରତ ଅଲି ଖାଁ ତା ଘରେ ଲୋକେ ସାହେବ ବେଗମଙ୍କୁ ମାରିବାକୁ ଧମକ ଦେଇଛନ୍ତି ଯଦି ପୁଷ୍ପାଞ୍ଜଳିକୁ ସୌତୁନି ଭାବେ ଗ୍ରହଣ ନ
The
କରେ।
marriage is valid because they are
Valid
Muslim.
are- ସେ କହୁଛନ୍ତି ତାକୁ
So-
ସୌତୁନି ଭାବରେ ଗ୍ରହଣ କର ବୋଲି ନ କଲେ raise all this point at the time.
Madam,
Your Lordship, I may pray, Lord. May I pray, Lord? I'm in this. Lord, I pray kindly taken up next week, my Lord.
No, I can hear you properly. You can argue. No problem.
Mr. Mishra will argue this matter. Being
No. After taking attempt and when the court is not agreeing, and now you are seeking
no, Lord. In faster, I also pray.
You should have asked for adjournment from beginning.
In faster,
I'll tell you, the allegation against you is 161 statement and all. It says that you have, during the subsistence of marriage of your husband, you have the relationship, you become pregnant, and then you married. Marriage is valid because in the Muslim you can have second wife, no problem. And after marriage, you started forcing your husband to get the divorce from the first wife. That's the allegation.
I'll
satisfy 498A, 109 and everything is foisted.
My senior will satisfied because there is talak is.
I am also satisfied. Don't worry.
Mr. Mishra will argue this matter. He is interested to argue this matter. Only in faster, I beg pardon, Lord. In faster, I'll pay adjournment.
The petitioner has challenged the order.
Your Lordship, can you glance the FIR itself first? I'll have for a moment. FIR, Your Lordship, can you glance? Sir, FIR.
Why don't you appreciate? You have challenged the order of cognizance. Try to appreciate. FIR is not everything. Thereafter, investigation is taken place and charge sheet has been filed.
Sir,
on the basis of the charge sheet, if prima facie case is made out, cognizance is taken. And
Sir,
if you say that on the basis of the material available on record, if particular offense is not made out, and you have to argue those things at the stage of framing of charges. I am giving that liberty to you. I am not absolutely dismissing it. I am giving that liberty to you. Argue all this point. Order dated by Chichod requisite passed by the Lieutenant SDJM bracket S Katak in GR case number 217 of 2021, where the cognizance of offense under section so offense under section 3 page 90 has been taken. The Lieutenant Counsel for the petitioner vehemently argued that from the allegation made in the FIR, no case against the petitioner is made out. I have perused the statement of the witnesses recorded under section 161 CRPC and the allegation level against the petitioner in the charge sheet. From the allegation, it reveals that the petitioner has married to the married to
Pushpanjali.
What is the name of the boy? Married to
Kudrat Ali Khan.
Kudrat Ali. Married to the main accused Kudrat Ali Khan during the subsistence after the first marriage of Kudrat Ali Khan. After the marriage, and she became pregnant before the marriage. After the commission of the second marriage by Kudrat Ali Khan, at the instance of the present petitioner, the complainant has been harassed, and it is further alleged that the present petitioner has been instigating Kudrat Ali Khan to divorce the informant. And not intend to interfere in the cognizance order in view of the nature of allegation made against the petitioner. However, liberty is granted to the petitioner to argue all these points before the court below at the appropriate stage. With this observation, the petition is disposed of.
My submission may be recorded, my Lord. Marriage already dissolved, my Lord.
Boy is now giving 10,000.
Yes, yes, no, 1 minute. What do you say, Mr. Swai?
Already divorce has been made. After divorce, the second marriage has been done, Lord. That may be recorded.
That Mr. Swine and counsel for the petitioner, however, submits that in fact after the divorce of after
Divorce.
What is that Khan? Kudrat Khan having divorced from the first marriage, he married with the present petitioner. Yes.
And one line added, my lord. Charge sheet is submitted against this petitioner, my lord, under section 493, 109, 34 for DPI.
Item 107.
2 o'clock.
My lord.
Ah. 27?
7.
7.
Because
Okay.
release on interim bail matter.
Okay.
No, lordship. How? 180
Lordship,
24
kindly see the order number 4, lordship.
You tell me the rate. Why should I?
Order number 1/8/2024. The petitioner availing the interim bail for the period of 21 days. Thereafter, the petitioner surrender on 27/8/2024. That I filed the surrender certificate at flag Z4, lordship. Kindly see.
Yes. 24. You are in custody since?
31/3/24.
31/3/24. Then you got bail on 27/7/2024.
1/8/2024.
1/8.
1/8/2024. By IA number 857.
And after 21, you have surrender.
Surrender.
27/8.
Yes, sir. Without any violation condition, I surrender before this court.
And you utilize this time by some
On the ground that
376. He has stated that he has deposed before the court below. That the victim. Let he file the deposition or he may file a 311.
Lordship, in the
if there is
meantime,
compromise.
he has already deposed before court against you.
No, lordship.
Decline hostile.
Already declined, lordship. Surrender certificate at the
Due to some misunderstanding, I had lost. Due to some misunderstanding, I had lost. FIR. Right. Petitioner is accused and so on. Allegation of the wide order dated. Which order is that?
And that is 11/4/24.
11/4/24 interim order. Huh?
11/4 rejection order.
No.
Interim order is
1/8/24.
Right, order dated 1/8/2024. The petitioner was enlarged on interim bail. He has surrendered on 27/8/2024 and filed the surrender certificate, which is taken out of court. Counsel for the petitioner submits that in the meantime, the victim girl has already been examined as PW2
on 11/9/24.
On
11/9/2024.
He has not supported the prosecution. C inter alia has stated as under para 2. Inter alia has stated as under in her deposition. Even today, the prosecutrix is present in the court.
Yes, sir.
What is she saying? What is her age?
Age, victim age 42.
40.
And the bail petition, her name may not be reflected because
I am not present. She is present in the court.
Yes, Lord.
And she submits that she has no object and being represented by the counsel. Counsel. She has been identified by the counsel and filed self-reported copy of the report. The victim, the prosecutrix, inter alia states on the query from the court that she doesn't have any objection if the petitioner is granted bail. The petitioner is in custody since 3/31/2024. Regard being held to the nature of acquisition, period of custody, and the fact that the prosecutor has not supported the prosecution case before the trial court, and she appears before the court and states that she doesn't have any objection if the petitioner is enlarged on bail. I'm inclined to admit the petitioner on bail. Accordingly, bail is granted. Yes.
Obliged.
75.
I am for the opposite party informant, my lord.
Yes. Petitioner, who is the petitioner?
Charge sheet has already been submitted, my lord.
75. What is he is asking what?
My lord, challenge has been made to the cognizance order, my lord. Offense under 447 and 506. My lord, the ground that they have alleged that cannot be a ground for quashing of.
Nobody is there.
State my lord, another my lord, notice.
Charge sheet, where is the charge sheet filed?
My lord.
Charge has been framed.
Charge frame is
Charge has been framed or not?
that I need to obtain instruction.
He is challenging the cognizance order. Charge has been framed or not?
Charge sheet is.
Charge sheet obviously.
I have no instruction.
You have to take instruction.
None appears for the petitioner in the interest of. He
I can move opposite party.
Don't show appears for opposite party in the interest of justice. That is December. December. Second petitioner. Yes.
May I please, Your Lord?
Yes.
My lord, the 311 petition of
PID matter. OPID matter. My lord, Mr. Patra is not there. Let it be passed over.
my lord, pass over or he is present.
What are you asking?
My lord, the 311 petition has been rejected.
76.
My lord, in the present case, my lord.
311.
My lord.
You are
On the
seeking recall of
PW1, my lord.
who is he?
The informant.
Why have you not cross-examined?
My lord, the fact is that in the first instance, the PW1, the present petitioner and other depositors made an allegation before the EOWPS. Thereafter, that matter was not disclosed. The PW1 lodged a report at capital PS. The present case is arising out of the capital PS.
I am asking, why have you not cross-examined? Why have you not put these questions?
But in the EOW case, the charge sheet, after submission of charge sheet in that case, the PW1 have disclosed many things that I have questionnaire that I have prepared. That questions I want to ask the confront.
That's what I'm asking. Why have you not asked?
Because my lord, in that case, charge sheet has not been submitted.
Which case?
In EOW case.
This is not EOW.
No.
Yes.
Copy the receipt of my
He is entitled to.
Copy
I would copy to problem. Next week. Just one opportunity I will grant, and subject to verification, subject to the trial court being satisfied, the relevancy of the question is going to put, and let him only one opportunity. Shall I allow?
Let me
Next week. Next week. Yes. 77. Yes.
77, my lord, on behalf of Mr. Let Mishra, my lord, kindly adjourn this matter.
What are you asking for?
That is cognizance taken under section 138A9.
I'll my lord, nice, but challenge on the
Stay with nahi.
Dear Mishra Nahan.
Stay is there? No. Notice was not issued.
Last week was listed on 31/7/24.
There is no order of stay. No. Adjourn. On the request, adjourn to November last December. Yes.
78.
Okay.
76 matter, my lord. Name of the B. Bhuya may be indicated.
B. Bhuya, 78. 76.
78 on behalf of Mr. Panda may kindly be adjourned to next week. He has some personal difficulties.
on
আপনার
request.
বেলজিয়ামটা আর্জন
হ্যাঁ
সে বেলজিয়াম ম্যাটার আর্জনিং
Belgium to. I'll allow what is this?
NBAA is issued, no steps has been taken. Bail was granted on 18/3/20. NBAA is 13/6/23.
Petition is agreed by the order dated 18/3/2020.
13/6/23.
18/3/2022.
No, no, 13/6/23. That is NBAA is issued, page 8.
Page
8, my lord.
8.
Order dated 62,
13/6/2023. Whereby the Lieutenant Sessions Judge has issued NBW against the petitioner in the Sessions trial case and a CT case number 80 of 2017. For the reasons stated in the petition, the NBW order of NBW is set aside. Petitioner is directed to appear before the trial court on or before 15th of October. 15th October, 15th of October 2024, and avail remedy under law. And the NBW is this petition is allowed subject to petitioner depositing a cost of rupees 500.
For the bar association.
Bar association. Okay, I allowed it. Yes. 79.
My lord, I am challenging the 1/6 case, my lord. This is 1/6 case I am challenging, my lord, and along with the cognizance.
Cognizance.
And my lord, the check is issued by the company, my lord, whereas the company is not the made party, my lord. Yeah. And the Onitara case, my lord, 2012 5 SEC.
Yes. Issue notice to opposite party number 2 returnable within a week. Sir.
My lord, I age there, my lord, first.
Sir, I will not stay. 2009 se the stay after granting state from 2009 petitions are pending. 1 week I am giving, come serve immediately, come after 1 week I'll decide it. Come after 1 week.
Hello.
Requisites to be filed, by tomorrow. File it. Yes.
Tomorrow, my lord, tomorrow is Saturday.
Huh?
Holiday, tomorrow is holiday.
Tomorrow is not holiday.
Second Saturday.
Second Saturday. By Monday and Tuesday.
Tuesday.
By Tuesday. Requisite to be filed by Tuesday. File immediately.
My lord, defect may be.
Ignore the defect. Forget it.
Okay.
I wish to notice what. Yes.
81.
Here's a case, my lord, where I have challenged the order of framing, the rejection of my framing of charge, my lord. But in the meantime, it has been proceeded further. After framing of charge, my lord, although about 7 times it has been adjourned, but the notice single witness has been examined. It's a case it's a case where the other co-accused person have already been acquitted. That is annex number 3. And there is absolutely no allegation against the person, 7 except that at the instance of the person, it is alleged that my lord, the offense has been committed. And so far the offense is concerned, that is 376D. Apex Court by the several judgment has also emphasized on day-to-day trial. So may I pray, my lord, direct the concerned trial court to dispose of the case within a specific time frame, my lord.
What do you say? Because the co-accused has been acquitted.
No, one convicted on 354, other acquitted.
Other acquitted, one convicted.
But it will not apply to the in the case of the.
He will face the trial.
He will be praying that to expedite the trial.
Expedite.
His challenge is the discharge petition, but you will
how much time one can?
2 months, my lord, witnesses are 10 in number, judgment, page
457, 397. 6 months, sorry.
6 months.
6 months, my humble submission, my lord, see. Day-to-day trial is my prayer because it's a case under 376, my lord.
Why so preferential trial? Because you are absconding.
No. I'm in custody. I was in custody. I was now on bail, and for the last 8 times the case has been adjourned.
Trial was pleaded because you were not there.
Yes.
So no preference, but you have to give a realistic target. You tell me the realistic target. Not that leaving every case, your case will be.
No. It has been trial. It's been trial by the fast track court, so there is absolutely no problem because the fast track court is now in taking over all sorts of things.
So therefore, give a realistic target. I'll pass that.
May I pray for 3 months?
3 months is realistic.
3 months not possible.
May not be. Again, he will move an application for extension.
May say preferable within 3 months.
You have a vast experience, you know.
No, my lord, with all respect, If the because the the trial court is posting that for each and every alternative ballot weeks ballot. So if 2, 3, 1, at least 1, 2 will come, it will dispose of within 3 months, ballot.
I'll say preferably within 3 months, maximum 6 months.
Ballot may not say 6 months, before 3 months, preferably it will cover everything, ballot.
Right. As soon as possible, preferably 6 months.
3 months.
Or petitioner is accused in so and so. He is agreed by the order dated 1/2/2023, passed by the additional sessions judge FTSC Chandrapura in ST case number 115 of 2023, whereby charges have been framed against him for alleged offenses under section
457, 397, 307, 3760.
Learned counsel, Mr. Chand, learned counsel for the petitioner, submits that 5 accused persons were subjected to trial for the same offense under the FIR in subject. The additional ad hoc additional sessions judge FTSC Chandrapura, while the judgment dated 17/6/2023 has acquitted 4 accused person and convicted 1 accused person.
354
sentence is said accused to undergo RI for
That is
354, 294.
RI for 3 years and to pay fine 5,000.
3 years and pay fine so and so. The petitioner was petitioner alleged to have been absconding, so therefore the trial was splitted. Subsequently, the petitioner has been apprehended, and he was
now facing trial.
apprehended. The charge has been framed by the impugn order.
And in the meantime, 7 adjournment has been given.
Chand, learned counsel for the petitioner, confine his prayer to the expedient disposal of the trial. Regarding it to the aforementioned, I am inclined to allow the prayer made by Mr. Chand. Accordingly, the trial court is directed to do well to see that the trial of the present case, qua the present petitioner, is disposed of as expeditiously as possible, preferably within a period of 5 months. Within a period of 5 months. With this observation, the petition is disposed of. Yes, sir.
Hon'Ble.
83.
I had taken notice on opposite part number 2, not done.
Notice, sir?
7/8/2000 returned on shop.
No such person in this address.
He has to file correct address.
I don't know. Learned counsel for the petitioner submits that since submits that he would be filing fresh address of opposite party number 2. If such address is filed, notice be issued to the opposite party. And he filed the fresh requisitions. Yes.
84.
Yes.
My lord, I have filed a petition for substitution in this matter.
Substitution.
My lord.
No, the appellant has died.
My lord.
I'll allow this and which IA is that?
My lord, IA is one. Miss case is 1328 of 2014. My lord.
1328 is you filed this application under wrong provision. 394 should be.
My lord.
All right.
It was filed.
Sole appellant in the present appeal has expired on 6/3/2013.
My lord, there are 2 appellants, I guess.
Both the appellant died.
No. Appellant number 2 is alive. And appellant number 3 is alive.
Now it is before Lawrence JMFC nearly. That one.
Nearly.
JMFC.
Appear before JMFC nearly. Yes.
Obligation.
Yes, next. 86. 87.
On behalf of Mr. B. Pujari,
Adjourn on the request, sir.
My lord, I am appearing for the OP number 2, your lordship.
He's asking for adjournment. I am just adjourned.
Great.
Yes.
88.
Opposing party.
Yes. Your lordship, kindly say order number 24, 4, 25.
Yes.
The last portion, paragraph 3 and paragraph 6.
Three and
6.
what is this order 23/11/2020?
Madam, there he was directed to deposit money. Your lordship has mentioned that
Where?
in paragraph 5.
5. The Land Council petition pointed out that on 23/11/2020, the Land Court below has, while allowing the application of the complaint 143 of the amended memo dated shown to pass an order directing the pay 3 lakh rupees. Yes, he has not paid.
No, last occasion he was not there, but still then your lordship was kind enough to extend the interim order, enabling him an opportunity. Last order your lordship may kindly say. Order dated 6/9/24. He was not there. I had opposed. As your lordship said that let him given an opportunity. He has not complied. This will be why the matter will be listed again, because it has been, your lordship has been made clear that without further reference to the benefit.
Has he, where from I'll get that he has not paid?
He has not paid. Your lordship will
I'll
not
record
pay.
it.
Yes. He has not paid. That's why last
Right.
occasion he was not
The
there.
matter was taken up for hearing on 24/4/2024 and the following order was passed. Pursuant to the said order, Mr. Bose, Land Counsel for the opposite party, submits that pursuant to the said order, the petitioner has not make good the payment as directed. The payment to be made, as directed by the trial court by the order dated 23/11/2022. There was a peremptory order passed on 24/4/2024. 24. Despite that, the matter was adjourned. The matter was listed on 13/8/2024 and Then on 4/4/2024, on both the occasions, the petitioner. 4 and 6/9/24 or 6/9/24, 4/9/24 and 6/9/24. However, the petitioner has not complied with the order dated 24/4/2023. Since the order dated 24/4/2024 was a peremptory order for non-compliance of the said order, the petitioner deserves to be liable to be dismissed. Accordingly, the CRLMC so and so is dismissed. Yes.
Connected matter is also same.
Connected matter? Yes, same, current order, dismissed, yes.
Grateful.
There also same order?
Same.
Same order?
Same non-compliance.
Non-compliance?
Same non-compliance.
Yes.
But two 1cc cases, two checks, two orders are checked.
Your matter is over. Already over. You want to recall of that or what? We are talking about some other matter. 18 here.
Forget that we have to board the Tejas train. We forget something.
Yes, that's right. Adjourn. And the request adjourn.
Lord, yesterday it was.
What do
Interview.
you want today?
No, let's see. Yesterday it was argued by my senior, and the interview order was there.
Oh, interim
Today-
order is there. That is the problem. Hello, he's not there. In any case, I'm going to rise. 91.
The petition to discharge that was rejected. Against that, as well as challenging the entire proceeding. There is an order 5/2/2024 by your lordship.
5/2?
5/2/2024.
5/2/24.
Here the co-accused persons have already been acquitted by two separate judgments. Man was not produced. Case got delayed for 12 years, last 12 years. And now without prior sanction, they have proceeded the matter. That's what-
Yes.
Page 53, sanction is there.
Sanction is there.
Valid sanction, it's not sanction. Valid.
My lord, whether it is a valid sanction or not, that has to be
That has
to
decided at the
be
time of
decided
trial.
at the-
But sanction was there, charge sheet was submitted.
Given the judgment of this Hon'Ble Court basing upon which the interim order was granted. Lordship may see the judgment in Sibo Das case. Why prior sanction is required? Because unless.
Subhasri Das.
Yes, Sibo, I have given.
On the
judgment.
conjoint trading, I have reproduced that in my order.
Yes, reproducing that. They are,
On the
they say
conjoint,
that
reading.
once the sanction is not that the entire proceeding is decided. If that is the law, yes, that is the law, then why should somebody face the trial? Sibo Das case, paragraph 9.
9.
Yes, paragraph 9 has quoted. Let me read. In the light of the aforesaid commissions in course of hearing that an additional government advocate for the state was asked to produce documents order of appointment of so and so special secretary issued by the appropriate authority appointing as the review authority under section 45(2) of the Act. To this query, learned additional government advocate fairly responded, no such former appointment was appointing the special secretary for the purpose of reviewing cases under section 45 of the Act is available on record. To further query of the court as to whether the state have prescribed any time limit for the purpose of producing such report by the reviewing authority, learned additional government advocate for the state also responded in the negative. In view of the aforesaid response of the state, it is clear therefrom that the state have failed to produce before the court any documentary evidence in order to establish that the appointment of the special secretary A.M. Prasad as the authority for the purpose of carrying out an independent review of the required under section 45(2) of the Act. I am also constrained. Note that the state have also failed to produce any document or order prescribing any time limit for.
You tell me the ratio, didn't you?
Yes,
Don't
ratio
read
that
it.
here. last
What is
line,
the
Lord,
ratio?
if may see paragraph 9, last line. The respondent.
No, no, actually paragraph 10, my lord. That
Paragraph
the
9, last 3 lines. In the case of Mananjan so and so, it is held, the Supreme Court held that it is also well settled principle of law that where there is no sanction by the competent authority, proceeding itself stands vitiated. If that is the
That's
law,
what he is arguing. There is
No,
a
he said
difference between no sanction
And
and
invalid
defective
sanction.
Yes, yes, sir.
It is a case of defective sanction,
No,
which has to be looked into in the trial only.
Unless the sanction is valid, but it is in the eye of law, it is no sanction.
It only says the statutory provision is no court shall take cognizance
Yes,
without
sanction. Yes.
If it is a invalid sanction
Yes.
and at the stage of cognizance, the court can't go into whether it is a valid sanction or not. Only the court has to see whether a sanction is there or not. On that basis, cognizance will be taken. Valid or not, that will be tested in the trial.
Yes, my lord.
That's the law. And the Subhasri also says the same thing. Para 10.
Para 10, my lord. It was.
They say if
I have
the law-
reproduced that in my order.
If the law, this is the law, my lord, if it's a procedure, special procedure is prescribed, it has to be followed in that way.
So therefore, you have to, it has to be tested
At the time of trial.
in the trial only.
If that is the case, my lord, I say, my lord, this is not a valid sanction. Now, this honorable court,
You simply say sanction was there or not.
Lord, I don't know now, they say that there is
Sanction was there. So cognizance is taken.
There
There is no bar to take cognizance.
The court at the stage of sanction, cognizance as well as the discharge also has the authority to see whether this is a valid sanction or not.
No.
No. At that time, how
You
they.
show me one judgment.
Well, I'll give the honorable.
You
justice-
show me one judgment where it is said that at cognizance stage court can go into the validity of a sanction.
Yes, my lord.
This
They
is
say
the
that-
fundamental. You can't get any judgment on
Say,
that.
my lord, if the sanction is not valid, what I say, why should the person face the rigorous of trial, my lord?
That is a different.
That is correct.
That's right.
The law is, see, the language employed is para 10 just see, para 10 of Subhasri, which you are reading. In view of the conclusion finding, reaching here and above, this court is of the considered view that no cognizance could have been taken against the petitioner in the absence of any valid sanction of the prosecution. And in this regard, although the sanction of the prosecution has been obtained, yet the same was not based upon the review of the validity appointed authority out of the independent.
Carry out the independent review of evidence.
So this has to be a mixed question of fact and law.
Yes, sir.
That has to be tested.
Prima facie, if the records come to the court, so that the valid sanction.
Okay, you show me at the stage of cognizance, the court has to see.
Cognizance or discharge?
Has to see.
Yes.
Has to, but you are challenging cognizance.
Yes, challenge the discharge, sir. Discharge.
At the stage of cognizance of charge, framing of charge, the court needs to go into the validity of the sanction. You show me on judgment. Then counsel for the petitioner submits that
And ask for a copy of the order. The sanction.
No, that is reflected in the charge sheet. That order sanction was obtained, that was reflected.
Then
in the
counsel for
charge
the
sheet.
state submits that there was a sanction. The sanction to prosecute the petitioner was granted on. Sanction granted on.
That
Sanction 54 page क्या बोलता भैया?
no, on the 53, my lord, that was sanctioned during in Sangram ke samay they produced the then my lord sanction order was prosecute to accused person Sangram Mohanty under section so and so has been obtained.
Obtained who? Date you tell me.
My lord, the date is not reported.
And the sanction order for prosecuting the petitioner was already obtained, and it was placed before the trial court along with the charge sheet. On that basis, the cognizance was taken, and subsequently cognizance was taken. Learned counsel for the petitioner submits that the sanction was completely invalid under law, and he further submits that it was obligatory on the part of the trial court to arrive at a satisfaction as to whether the sanction was valid under law or not. Valid under law. He wants to he wants to rely upon certain judgment of the Honorable Supreme Court regarding regarding the duty cast upon the trial court to go into validity of a sanction order at the stage of framing of charges.
Well, just another point is there. 124A section IP that was stayed by the Honorable Supreme Court.
That we'll see.
That there.
That we'll see. That we'll see. First you get that order. Yes.
The interim order to continue.
Interim order to continue.
State-
Any very urgent matter? Very urgent matter. Otherwise, all the matters will be rolled over to next working day.
Item number 95, this is covered by my lord judgment. And earlier.
Urgent or not, covered, I'll check it out. Only super urgent, you tell me.
93. Item 93.
Covered, but the other side has to see that.
My lord here.
Covered.
What is the similar order which day before yesterday you are going to pass, it will be equivalent.
See, now what happened, he has taken some point. That those valid point, I have to deal with that. Let me pass that order thereafter.
Well, I don't know, compromise item.
Compromise.
Your Honor, item number 100.
100, yes.
Sorry. Yeah, no, 100 on 16th of this year, on May of this year, the order is been passed by this honorable court to pay the interim maintenance, to pass to the petitioner to pay the interim maintenance. Even I have given my account number also, but till now he have not paid any a single money also.
I am appearing for the petition husband. The opposite party wife has filed a modification of order. That copy has not been served to me.
They are not taking.
Are you paying interest?
Yes,
No.
I have already paid your lordship.
Not paid.
Your lordship
This
directed
is, I have given my
Yes, I paid, you say not paid.
Day before yesterday, I have paid 58,000 towards the tuition fees of my ward. Your lordship directed, the last exam lordship directed to.
not even single pie.
He
I
said
have given.
58,000 rupees he paid you.
This is the due. I have not given the papers, that's why.
Madam,
it is-
in this proceeding, I am not here to calculate how much is paid, when paid, and
Your Honor.
then I'll have to leave everything. I'll keep on waiting how much you paid and how much.
Your Honor, the main order has been stayed by this honorable court, my district and session judge.
According to him, I record his statement that he has been paying the interim maintenance. He'll keep on paying it.
Not paid, not interim maintenance, not even full what?
You give me the particulars when you paid.
Your lordship, I have deposited 58,900 towards the tuition fee of my ward.
And then what?
Yes.
The lordship directed to the opposite party wife, whatever amount to lying outstanding before the school, you give the particulars, accordingly, I will ready to pay the clear the entire due.
There is the entire in the court.
However, I have, after getting information from the school, I have deposited 58,900 towards the outstanding.
Madam, can I suggest you one thing?
Yes.
Tell you honestly.
Give me a copy.
I'll suggest you one thing. Since you are fighting the case in person,
Yes, yeah.
this is not good for you.
Yeah,
You
yeah.
are emotionally attached with the case.
Yeah.
It is better that you should ask one of your brother or sister who can fight the case for you. Then only the case can be concluded. Right to appreciate that. I on your behalf, I will request if you someone to appear free of cost. He's standing behind you. Just see, he is such a senior person. He will assist me. Please give the papers. Let him appear for you. Okay.
Okay.
You don't argue yourself.
Okay.
Okay. Please help, sir. She is a member of this bar. And you know, when a doctor operates himself, what happens? He is spoiling her case. Give the papers to him, and he will work for you. And I am listing it next week. We'll work it out.
Yeah, you are not taking. How many times I?
No, don't argue with him.
Yeah.
He is doing his job as a lawyer.
Yes.
Don't argue with him. That is the problem you are creating for yourself.
Yeah.
Don't do that. Give it to sir, and he will argue. I'll put it Tuesday, Wednesday. Okay.
Your Honor. Your Honor, can you please make out the stay order?
Whatever
vacate the stay
request
order.
has to be made, it has to be made by sir only.
Okay.
Not-
Obliged. Obliged.
I will not entertain any request from you.
Obliged.
Give the paper to him and you do it. He knows what to do.
Okay.
Fine.
Come on, get two, maybe take that next week.
It will remain.
Yes.
It will remain. Roll over.
If it is taken in grace and is done, it may be disposed of.
Grace certificate okay. Because ability is
Disposed of.
grace certificate. 102 record you lease the matter in the fresh admission.
102 grace admission.
Category.
My lord, item 103. Item 103, my lord.
That matter item.
138
Let us see if it doesn't happen then. Oh, 138.
Yes.
We can dispose it.
For defense evidence, since January it is legal.
I can dispose it up by concluding direction to conclude the trial.
No, here I have prayed for before the learned trial court.
Oh, that matter.
No, not that matter. Here the signature and contents of the check and age of the ink. I filed a petition therein, and that was rejected by the learned magistrate.
We'll see.
My lord, may I please, my lord?
If it is very urgent, to tell me. Otherwise, it will remain in the board. It will be taken up. Don't take it up.
May I please, my lord?
Unless it is extreme urgent, you tell me. Yes, yes.
Sadhya mention kari koitha. He has suppressed all these things.
No, I have objection, madam. Last order, madam, kind of last order, using last client. The client came to the court, the DB proceeding has been stayed. He is showing some photographs that they are unable
But
to.
he is entered appearance. That to at least a week. After 1 week. After 1 week.
Fixed date, madam.
Why such a senior person will?
I know. I am not blaming the
Respect the senior.
I am blaming the client, not through.
Anyway, yes.
May I please?
Kindly fix a date, madam.
Can I submit with your lordship?
Yes.
It will take 1 second for the item 99. In 99, they have suppressed all these things. They have challenged the cognizance order. This honor could dispose of the matter, directing to the petitioner.
My lord, I am for the petitioner in this case, item 99. May I
Yes.
submit before this court?
What is the so urgency? I can hear it.
Not urgent. Not urgent, my lord. That has been disposed of.
It will remain in the board, sir. I am not adjourning it. Let it be.
Madam, next week ro no asi karan next week ro mu nothi bi ta pore asu.
My lord, only that order dated 10/9/24.
24. 99 and 24.
Can I pray?
It is made clear that no further judgment.
Top of the, because it will take 1 second. My friend knows everyone.
You 1 second see.
No.
Full on.
My lord, kindly see the order dated only that order 10/9/24. That order you should be kindly see that is.
Wait, I'll see on that.
No, not that.
24. 24.
I may be pardoned.
Yes, Mr. Pradhan, you wanted to mention something.
Next week, as you kind
That's what I'm saying. Let it be there. Extreme urgency, you tell me. If you can't wait till Tuesday. Any bail matter or anything, I can do it. 90? Thank you.